I would like to call our hearing to order this morning, and today's title is EPA's Proposed 111D Rule for Existing Power Plants, Legal and Cost Issues. And we have two panels of witnesses this morning, and I want to thank those of you on the first panel. I will be introducing each one of you before you give your opening statement, and you'll be given 5 minutes at that time. But before we are able to listen to your marvelous opening statements, you have to listen to our opening statements, which sometimes is not quite as exciting to people. But at this time, I'd like to recognize myself for a 5-minute opening statement. As I said, this morning our subcommittee will hold its first hearing this year on EPA's proposed Clean Power Plan. We will examine specifically the circuitous and tortured rationale, in my opinion, of EPA that Section 111D of the Clean Air Act grants them the authority to regulate CO2 emissions from electric generating units that are already regulated under Section 112. We're also going to look closely at the impact on states and consumers. It appears that EPA is, excuse me just 1 minute. Given the stringency of this EPA proposed rule regarding CO2 emissions at existing coal plants, states are going to be forced to adopt state implementation plans within 1 year. And this regulation is so onerous for coal generation that, according to EPA's own projections, the amount of coal for electric generation in America would decline by 40% from the 2009 levels. The well-respected economic consulting firm NERA concluded that the proposal is the most expensive environmental regulation ever imposed on the electric power sector, costing between $41 to $73 billion per year, with 14 states facing peak year electricity price increases that are likely to exceed 20%. Regional grid reliability coordinators have begun warning that the rule will cause portions of the grid to suffer cascading outages and voltage collapse. The North American Electricity Reliability Corporation recently produced an initial analysis that questions the validity of the basic assumptions underlying the rule and raised a multitude of concerns as to how the rule will affect the grid. This proposed rule has been described as a power grab, extreme, radical, unprecedented, and a violation of existing law. I agree with those characterizations. Even EPA has acknowledged that a literal application of Section 111D would likely preclude its proposal because the electric generating units are already regulated under Section 112. This proposed regulation would create turmoil in the generation, transmission, and distribution of electricity. It is being proposed because the President was unable to convince Congress to adopt a cap-and-trade legislation, and he has made international commitments without input or advice and consent from Congress. And in his Georgetown speech, he committed the U.S. to an extreme policy. It appears that EPA is trying to find a way to implement the President's plan pursuant to his international commitments, even though EPA has readily acknowledged that this proposal would not make a measurable difference in addressing climate change. So this is a significant issue that's going to have a dramatic impact on everything relating to electricity generation in America. And it is our responsibility to make all of this transparent, to give the American people the opportunity to be aware of how extreme this is and what a fundamental change it would make, and to address the question, is it really legal? And that's what we intend to do today. That's why we're thrilled with the panel of witnesses that we have. And with that, I would like to recognize the gentleman from California for his 5-minute opening statement.
Thank you, Mr. Chairman. You mentioned this is the first hearing on this issue this year, but it's our 4th hearing on this issue in the last few years. So climate change is here. I mean, it's happening. It's not a matter of speculation. We need to take action. We need to take it now. The longer we wait to take action on climate change, the more expensive it's going to be, the more damaging the effects of climate change are going to be. So it's incumbent upon us to do something about it. But the good news is that if the United States takes the lead, then we're going to be able to develop technology. We're going to be able to export jobs. I mean, we're going to be able to export materials. It's going to be a win for the United States. So we might as well embrace this now. Taking steps to curb carbon emission will have beneficial impacts, such as repairing and replacing aging infrastructure with very high efficiency infrastructure. Now, I know that the coal producers are worried about this, but my advice to them is embrace carbon sequestration. Embrace it, because coal is going to be reduced, whether we like it or not. But if we embrace carbon sequestration, then we'll be able to continue to use coal and keep those important American jobs. So that's my advice to the coal producers. But we're going to be able to increase our clean energy sources, renewable energy, energy efficiency, and so on. So I think this is an opportunity for us. Now, the Clean Air Act does give the EPA administrator the authority to put in place measures to reduce carbon dioxide production, and this authority has been upheld in the courts. Now, I think we're going to hear some opinions about that this morning, but it's already been upheld in the courts. Now, the administration's, the EPA's proposal, in my opinion, is reasonable. It includes energy efficiency. It includes looking for new, more efficient sources of energy, and using demand issues to help us reduce our carbon emissions. Now, the administration does have the responsibility to take action to protect us from the effects of climate change. So that's exactly what the Clean Power Plan does. 14 states in the United States, including my home state of California, have embraced this proposal. In a letter to the EPA, they wrote that even greater levels of cost-effective carbon pollution reductions from the power sector are achievable in this time frame using the system described by the EPA. The EPA found that the power sector could reduce its emissions by 26% below the 2005 levels under this initiative. That's a lot. 26% reduction of the 2005 levels. That's significant, and that has put us in a leadership position. It's given other countries like China a motive to start reducing their carbon emissions, which is absolutely critical if we want to reduce carbon emissions in time to prevent the worst impacts of climate change. So this is really a win-win. But another thing that's really important is that the level of the amount of outreach that was done with this proposal was really unprecedented. The rule that we have in front of us is not final. So it is important for us to continue examining this issue and to hear from all the stakeholders and work together to find something that's going to benefit our nation, put us in a leadership position, increase the economy, economic growth, and help stop climate change before the worst impacts are felt throughout the United States and throughout the world. So with that, I'm going to yield back, Mr. Chairman.
Thank you, Mr. McNerney. At this time, I'd like to recognize Chairman of the full committee, Mr. Upton, for 5 minutes.
Thank you, Mr. Chairman. You know, today we continue our examination of what many folks believe is the most problematic of all the global warming-related regulations being churned out by this administration, the proposed Clean Power Plan by EPA. and I welcome our witnesses who are going to be discussing both the legal and the cost concerns with this proposed rule, as well as the looming compliance difficulties at the state level. The Clean Air Act has been around since 1970, and we know from experience that it works best when implemented in the spirit of cooperative federalism. We've proven that we can accomplish a great deal to improve air quality when federal and state governments work together as partners. However, this proposed rule yanks the rug out from underneath the states, with the EPA dictating to the states and effectively micromanaging intrastate electricity policy decisions to agree even the agency admits is unprecedented. This raises a broad array of legal issues, not to mention that it's bad policy. As a result, many states are sounding the alarm about the legality of the rule and the implications for their citizens and their ratepayers. In addition to significant constitutional and other legal questions, states have expressed concerns about the feasibility of EPA's proposed requirements and the likely impacts on electricity costs and reliability. The risks to ratepayers are especially serious in states that rely on coal for a substantial part of their electricity generation. Under the Clean Power Plan, states would be forced to redesign their electricity generation, transmission, and distribution systems and related laws and policies, and to do so over a short time frame. Long-standing policies would be essentially wiped clean, and jobs and family budgets could suffer as a result, particularly for the most vulnerable. Today, we're going to hear several perspectives from both legal experts and state environmental and energy regulators. I am particularly concerned about the impacts on states, such as Michigan, which has a significant manufacturing sector. American manufacturers have shown that they can compete with anyone in the world unless they face an uneven playing field caused by unilateral regulations like the EPA's proposed plan. Other EPA regs, like the utility MAC rules, have already contributed to rising electric rates and growing concerns about reliability. With the economy still far from fully recovered, the last thing job creators need is another expensive regulation likely to drive up energy prices. And the last thing struggling families need is to see their electric bills go up as well. So I hope that today's hearing will inform our efforts to develop common sense policies that will ensure that electricity remains affordable and reliable in the coming decades. Jobs in the economy certainly are very important, and they remain our focus, and we'll continue to work to keep the lights on and the electricity bills affordable. And I yield to other Republicans wishing to speak. If seeing none, I yield back the balance of my time.
Gentleman yields back. This time I'd like to recognize the gentleman from New Jersey, Mr. Pallone, the ranking member on the committee.
Thank you, Chairman Whitfield. As we sit here today, unchecked climate change continues to reshape our world. According to NOAA, 2014 was the warmest year ever recorded, and 9 of the 10 hottest years have occurred since 2000. We know this warming is due to carbon pollution from fossil fuels accumulating in the atmosphere, trapping more heat and changing our climate. We can already see the effects of this warming in rapidly melting ice sheets and glaciers, extreme droughts and wildfires, increased storm damages, shrinking coral reefs, and beyond. Globally, the costs of these impacts easily reach into billions of dollars each year, and that trend shows no sign of slowing down. To that end, EPA has proposed a workable plan to reduce emissions of carbon pollution from power plants, which are the largest uncontrolled source of man-made greenhouse gases in the U.S. Today we'll hear more about the Clean Power Plan, but there are a few features that merit emphasizing in advance. First, the Clean Power Plan is not a one-size-fits-all proposal for reducing emissions. It uses a flexible, state-based approach that takes account of each individual state's unique capacity to reduce emissions from its electricity sector. Second, EPA is not proposing that states act overnight. States have until 2030 to meet their final goals, and the plan's interim goals don't begin until 2020. Third, the Clean Power Plan falls well within the legal authority and responsibility of EPA to address carbon pollution from power plants. The system-wide approach is based on the plain language of the Clean Air Act. And finally, and perhaps most importantly, the Clean Power Plan is just a proposal and is not yet finalized. EPA received over 3.5 million public comments on the Clean Power Plan and is reviewing these comments as we speak. EPA can and will make adjustments to its proposal. EPA is looking hard at a range of issues relating to timing, reliability, technical, and legal issues, and EPA is working in close coordination with states, utilities, grid operators, and other federal agencies like DOE and FERC to make sure the plan is done right. And there are those who deny science. They claim that climate change is not real or man-made, that it's caused by natural cycles or sunspots, and that simply is untrue. The world's leading scientists have told us that climate change is happening, is caused by humans, and will have extremely serious impacts. The Republican-led Congress has not listened to the scientists and has yet to take action to address these serious climate threats. And just saying no isn't an option anymore. We must reduce our carbon emissions, and the Clean Power Plan is a reasonable first step. So those who have concerns with EPA's plan have a responsibility, in my opinion, to not just criticize it, but also to propose alternative ways to achieve the same goal. There are always those who are willing to make absurd arguments on behalf of companies that profit from the status quo. And we'll hear today from some of these that EPA's plan is not legal, that it's unworkable, that some states may refuse to participate. But I think that those making those arguments aren't really interested in finding solutions to our carbon pollution problem. They're not interested in developing a plan to help us reduce emissions while still maintaining a safe, reasonably priced electricity system. To quote the words of EPA Administrator McCarthy, they're just trying to put their heads in the sand. They're more than welcome to do that, but history will not treat them kindly. Keep this in mind as we listen today and during future hearings and debates on the Clean Power Plan. I think you will be able to recognize those who are simply arguing for inaction on behalf of entrenched fossil fuel interests and compare them to those who want to act on climate change and also want the development of our path forward to be thoughtful, sensible, and effective. So for my part, I'm in the latter camp, and I urge all of my colleagues to join me, and I look forward to hearing from the witnesses. I don't think anybody on my side wanted time. Is that correct? So I'll just yield back my time. Thank you, Mr. Chairman.
Gentleman yields back. Thank you very much, and that concludes our opening statement. So now we'll turn to our panel of witnesses, and I'm going to introduce each one of you individually before you give your opening statement. So our first opening statement will be given by Mr. Lawrence Tribe, who is the Carl Loeb University professor and professor of constitutional law at Harvard. Professor Tribe, welcome, and we look forward to your testimony. You're recognized for 5 minutes, and be sure to turn the microphone on because it's not on automatically. So thank you.
Mr. Chairman, members of the committee, I'm honored to testify about EPA's proposed CO2 power plant regulations. I've submitted my full written statement for the record. EPA's proposal raises grave constitutional questions, exceeds EPA's statutory authority, and violates the Clean Air Act. First, the plan conflicts with settled principles of federalism and Supreme Court precedent because it would commandeer state governments, treating them more like marionettes dancing to the tune of a federal puppeteer than like laboratories of democracy. It would dictate the CO2 emissions target that each state must adopt within a year, commanding every state to enact an EPA-approved package of laws meeting that target by requiring power plants to shut down or reduce operations, consumers and businesses to use less electricity and pay more for it, and utilities to shift from coal to natural gas and other energy sources, a total overhaul of the state's way of life. Now, reducing states to this submissive role would confound the political accountability that the 10th Amendment guarantees. EPA's plan would increase energy costs over local opposition while cloaking that increase in the emperor's garb of state choice, with state governments taking the blame for policies actually dictated and necessitated by EPA. A state that submits no plan meeting EPA's approval by 2016 confronts a centrally planned and administered federal scheme of uncertain scope, burdening the state and its citizens, backed by draconian sanctions like the loss of federal funds under pre-existing anti-pollution programs. Prominent defenders of the EPA's proposal necessarily concede that non-complying states gambling on whatever unpredictable backup plan EPA might impose would be at a huge disadvantage. EPA's proposal also presents serious Fifth Amendment problems. We are all CO2 emitters, and atmospheric CO2 is the intermingled result of all human activity. But EPA would impose costs that ought to be borne equitably by everyone on a small group of power plants and companies after requiring those same companies to invest billions of dollars to reduce their non-CO2 pollutants over the past 25 years. The Constitution demands just compensation to rectify that bait and switch. Now, courts would never assume a congressional design to confer such revolutionary and constitutionally dubious power on EPA unless Congress clearly said so, but far from it. Under the very Clean Air Act provision that EPA invokes, Section 111D, Congress expressly prohibited EPA from doing exactly what it proposes to do here, regulate emissions from coal-fired power plants under Section 111D when those same power plants are already being regulated in costly ways under Section 112. In 1995, EPA itself read the Clean Air Act to prohibit such duplication, as did the D.C. Circuit Court of Appeals in 2008 and the U.S. Supreme Court in 2011. If the Clean Air Act's meaning were ambiguous, and it isn't, settled principles of statutory interpretation would mean that EPA and any reviewing court would have to interpret the Act to avoid the constitutional difficulties that EPA's interpretation raises under the Fifth and Tenth Amendments. Now, to circumvent that avoidance principle, EPA resorts to sheer fantasy. It claims that Congress enacted a law in 1990 that never made it into the U.S. Code, and that everybody has been using the wrong version of the statute for the past quarter century. Really? Crediting that story would call into question dozens of similar statutory provisions throughout the U.S. Code. The tale is pure fiction. There is no mistake in the U.S. Code, but even if Congress had truly tossed two different bills in the air and told EPA to decide which one to catch and run with, that would be a power Congress could not give away and EPA could not recognize and exercise. It is a lawmaking power that belongs only to you, backed by a judicial power that belongs only to the courts. EPA is attempting an unconstitutional trifecta, usurping the prerogatives of the states, Congress, and the federal courts all at once. Much is up for grabs in this complex area, but burning the Constitution of the United States, about which I care deeply, cannot be part of our national energy policy to deal with the problems of climate change. Thank you very much.
Thank you, Professor Tribe. At this time, our next witness is Allison Wood, who's a partner at Hunt & Williams, and welcome. We appreciate your being here, and you're recognized for 5 minutes.
Good morning. It is an honor to appear before this subcommittee to offer testimony on EPA's proposed Section 111D rule. I have practiced
Ms. Wood, if you, excuse me one minute, would you just move the microphone a little closer?
Absolutely.
Thank you.
Thank you. I have practiced environmental law for over 16 years, and for the past decade, my practice has focused almost exclusively on climate change. EPA's proposed rule suffers from a great many legal infirmities, and I will focus on two of those today. The first defect is that EPA is prohibited from regulating electric generating units under Section 111D because those units are already subject to regulation under a different provision of the Clean Air Act, Section 112, which regulates sources of hazardous air pollutants. Section 111D has always been a little-used provision of the Clean Air Act that was designed to catch the handful of sources that were not regulated under the Act's other major provisions. Indeed, this provision has been used to regulate sources only 5 times since 1970. The confusion over this point comes from 2 amendments that were made to Section 111D during the 1990 amendments to the Clean Air Act, both of which appear in the statutes at large. EPA claims this leads to ambiguity, but in fact the codifiers properly included in the United States Code only the House Amendment, the amendment that clearly precludes regulation under Section 111D of source categories that are regulated under Section 112. This was appropriate given that the managers of the Senate bill had expressly receded to the House amendment. The second legal defect involves EPA's overbroad interpretation of the term system of emission reduction in Section 111. In every other rulemaking under Section 111D, EPA looked at existing sources to see what technology and processes were in place to limit pollution. EPA then based its determination of the best system of emission reduction for those types of existing sources on the known and demonstrated technologies and processes that were in use. States then applied the system of emission reduction to existing sources within their borders that did not yet have these pollution controls, while taking into account several factors, including the source's remaining useful life. In this rulemaking, EPA turns this established procedure on its head and proposes for the first time a standard of performance that is based on not operating the source. EPA claims for the first time, based on the dictionary definition of the word system, that it can regulate any set of things that leads to reduced emissions from the source category overall, even if those things go beyond the fence line of the plant. EPA's new interpretation is fundamentally flawed. A system of emission reduction must begin and end at the source itself. EPA's interpretation would allow the agency endless regulation over all manner of things that are completely outside its purview. To use an illustration that may help people better understand what EPA is proposing to do here, it is as if EPA were requiring car owners not only to have catalytic converters on their cars, but also to travel a certain amount of days per week by bus, purchase a certain number of electric vehicles, and work from home 1 day a week. All of these things would reduce overall car emissions, but they do nothing to reduce the rate at which those cars emit pollutants per mile, and most people would surely agree that the Clean Air Act would not allow EPA to require these types of things from car owners. Yet this type of regulation is exactly what EPA is trying to do to power plants in the Section 111D rule. Finally, it should be noted that litigation over this rule will absolutely occur when it is finalized. Unfortunately, litigation takes time, and states are going to be forced to act before courts determine whether the Section 111D rule is lawful. State plans must be submitted within 1 year after the rule is finalized unless a partial plan is submitted and EPA grants an extension. These plans will be very complex, and states have never before had to submit a plan under Section 111D of this magnitude. Many states will need to pass legislation as part of their plan preparation. Regulations will need to be promulgated. Litigation will not be resolved before these things happen. Under this timing, any victory the states achieve will end up being hollow. A victory will not be able to give the states back the resources that were expended in plan development, nor will it solve the issue of states having to go through the time-consuming and uncertain process of unwinding legislation and regulations that were passed to put the plan in place. Thank you again for the opportunity to testify today.
Thank you, Ms. Wood. At this time, our third witness is Professor Richard Revesz, who's the Lawrence King Professor of Law, Dean Emeritus, and Director of the Institute for Policy Integrity at the New York University School of Law. And thank you very much for being with us today, Professor, and you're recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you for inviting me to testify before the committee. My written testimony covers 4 main points. First, the Clean Power Plan is a natural extension of previous EPA policies stretching back decades and promulgated under both Republican and Democratic administrations that use flexible compliance mechanisms to address the environmental harms of power production. Second, the Clean Power Plan does not give rise to any constitutional problems. Third, EPA has clear authority to implement the Clean Power Plan under Section 111D of the Clean Air Act. And fourth, EPA's proposed guidelines under Section 111D are authorized by the statute and based upon demonstrated approaches that some utilities and states have already taken to reduce greenhouse gas emissions. On the first point, for the past quarter of a century, each president has taken measures to regulate the emissions of existing power plants because they are the nation's largest sources of many harmful air pollutants, including mercury, sulfur dioxide, and carbon dioxide. Under the administration of President George H.W. Bush, Congress enacted the 1990 amendments, which capped sulfur dioxide emissions from existing power plants and established an innovating trading mechanism to achieve reductions as cheaply as possible. Later, the administrations of President Bill Clinton, George W. Bush, and Barack Obama each promulgated important regulations requiring existing power plants to reduce emissions of smog and particulate precursors that negatively affect air quality in downwind states, again using cost-effective, flexible trading mechanisms. And finally, the administrations of both President George W. Bush and Barack Obama issued rules limiting emissions of mercury from existing plants. Like these earlier programs, EPA's Clean Power Plant will cost-effectively reduce pollution from existing power plants through a flexible program that enables states to rely on traditional regulation, emissions trading, or any other tool that they may prefer. My second point on the constitutional issues. The first claim made by opponents is that there's a problem with the way Congress delegated regulatory power to EPA under Section 111D because the House and Senate passed arguably inconsistent amendments to the provision in 1990. Both the House and Senate versions were then included in a conference bill that was passed by each chamber and signed by President George H.W. Bush. In all of our history, the Supreme Court has struck down only two statutory provisions as constitutionally impermissible delegations to administrative agency, both in the mid-1930s during its skirmishes with President Franklin Roosevelt over the New Deal. Supreme Court has never invalidated federal statute non-delegation grounds on the basis of the argument that opponents of the Clean Power Plan now advance, that a statute has arguably inconsistent provisions. Instead, the courts have consistently dealt with this problem by finding ways to develop a workable interpretation of the statute. Opponents of the Clean Power Plan make a similarly far-fetched argument that the plan violates the Takings Clause of the Fifth Amendment, which protects private property rights. A regulation leads to a takings violation only if it deprives an owner of essentially all of the value of his or her property, which is not the case here. And even if it were, the appropriate remedy is a subsequent suit for compensation, not the invalidation of a nationwide rule. Finally, opponents claim that the Clean Power Plan runs afoul of the 10th Amendment's prohibition against the commandeering of state institutions by the federal government. This extreme and unsupported interpretation of the 10th Amendment would invalidate many of the core provisions of the Clean Air Act, not only Section 111D. In fact, it is the basis for how the National Ambient Air Quality Standards under the Clean Air Act, which are the centerpiece of the statute and have been its centerpiece since 1970, are administered. And nothing here is commandeered anyway. The states are merely given the option to submit plans if they choose to do so. If they do not, the federal government has the authority to impose federal implementation plans that give rise to no constitutional problem at all because they do not involve state institutions. The third point, the statutory point. Congress passed two amendments, the House Amendment and the Senate Amendment. The opponents of the Clean Power Plan would like us to ignore the Senate Amendment because it was not included in the U.S. Code by the Office of Law Revision Counsel. But everyone knows that a mere functionary cannot supplant the will of Congress. To do so would violate the principles of bicameralism and presentment. And in any event, even the House Amendment, which the opponents of the Clean Power Plan would like to credit, is not subject to a single interpretation. It's subject to multiple interpretations. And under traditional principles of statutory construction, the interpretation by the agency, by EPA, is entitled to deference in the courts. And finally, on the claim that the Clean Power Plan violates some provision of the Clean Air Act because it regulates beyond the fence line, the product here is electricity, not electricity produced by coal. And EPA has the authority to define the system in that way and has done so. Thank you very much, and I'd be delighted to answer questions.
Thank you, Professor Rivez, and thank all of you for your statements. At this time, the members have an opportunity to ask questions, and I'd like to recognize myself for 5 minutes this time. Ms. Wood, we've heard a lot of discussion about inside the fence and outside the fence. And as I said in my opening statement, this regulation has been characterized in a lot of different ways, extreme, radical, power grab. Would you explain from your perspective of why this is so significantly different in that it allows outside the fence solutions? turn your microphone on.
Yes, thank you. The outside the fence line nomenclature is being used a lot. Indeed, you can't even go beyond the source itself. So here we're talking about the actual electric generating unit. And the reason why people talk a lot about going beyond the fence line with this rule is that of the 4 building blocks that are set forth in the rule, only one of them actually gets any kind of emission reduction at the source itself. And that's building block 1 that has to do with energy efficiency improvements that can be made. All of the other building blocks take place somewhere else beyond the source, outside the fence line. This has never been the case with any other rulemaking under Section 111D.
Never been the case before.
No.
I take it that a state would even be able to mandate the type of material used in a building under this regulation if it's adopted. Would that be correct? In order to meet the overall emission cap?
Right. Exactly. You could, add a building block 5 that would say you have to have Energy Star buildings to try to reduce energy consumption. I mean, that could also arguably fall within the building block 4, which is designed to have consumers use less electricity.
I mean, I thought your illustration was very good about the driving to work. You could be mandated to take a bus. You could be mandated to this vehicle or ride a bicycle certain days, whatever, but it doesn't do anything about reducing the emission of your automobile.
Right, and that's exactly the point of beyond the source or beyond the fence line.
Yeah.
The emission reductions that you would get, from not driving your car one day a week have nothing to do with the car running and getting and emitting less pollution. It has to do with the car not running.
So, Professor Tribe, do you agree that this inside the fence, outside the fence is a radical change for EPA?
Mr. Chairman, I agree very much that it's a radical change, and it's a radical change that bears on what this committee needs to think about in several ways. First of all, I think it shows how unrealistic is the claim that, there's nothing going on here, just move along, don't bother, which is, I think, the essence of Professor Revez's testimony. No constitutional problem, nothing new, but it's radically new. I mean, we should all, I think, be honest with ourselves. Yes, many people think that there are severe problems that need to be addressed, but the question is, do we care about the rule of law and how we go about addressing them?
Right.
Now, the way that a court, if a court gets its hands on this, would look at the outside the fence issue isn't just as a technical matter, inside, outside. It would look at it in terms of no limiting principle.
Right.
As a number of state attorneys general have said, if the EPA can do this, it can tell you how often to use your electric toothbrush.
And the EPA's even had legal memorandums themselves saying that they didn't think they had the authority to regulate under 111D.
That's right. In 1995, they didn't think they had the authority. They were told in 2008 by the D.C. Circuit they didn't have the authority. In 2011, the U.S. Supreme Court told them they didn't have the authority, and they say, never mind.
Yeah. Well, why wouldn't they regulate under Section 108?
Well, 108 to 110, with respect to the national ambient air quality standards, really don't fit this very well, or else you could be sure that they would go that route. The reason they don't fit is that they're really based on state designation of geographical areas within the state as attainment, non-attainment, or unclassifiable. I'd hate to live in an unclassifiable area. But the point is that CO2 commingles with everything uniformly throughout the global atmosphere.
Right.
And so you really couldn't approach it by making the findings. And besides, the findings that you'd have to make under 108 to 110 would be very difficult to make and would require a procedure that they haven't gone through.
And they can't do it under 112 because CO2 is not a listed hazardous air pollutant.
Right. Under 112, there are 188 hazardous air pollutants listed by Congress. Nobody claims that CO2, which is essential for life, is hazardous in that sense. They try to split hairs by saying, well, it may not be hazardous, but it's dangerous. But we're not writing a novel here. But we're talking about a law passed by this body, and I'm concerned that, I've cared about the environment ever since, I was a kid. And I taught the first environmental law course in this country. And I've won major victories for environmental causes. But I'm committed to doing it within the law. And there is a legal way to address these problems. They tried to get cap and trade with this administration. Didn't work. And I guess the EPA is now following a kind of marching order saying, well, if you can't do it through the lawful way, just take an agency and tell it to bend and twist and tear and rip the law. And when I use the metaphor that burning the Constitution is not a good source of fuel for dealing with these problems, I was being metaphorical only in part. I mean, when you tear the Constitution apart bit by bit and give it the, death by 1,000 cuts, what else will we sacrifice the Constitution for?
Thank you, Professor Tribe. My time has expired. At this time, I recognize the gentleman from California for 5 minutes.
Thank you, Mr. Chairman. Mr. Brevitz, or Professor, would you describe what the Supreme Court actions have been thus far with regard to the EPA that's applicable to this to the Clean Air Plan?
Sure. The Supreme Court has never said anything.
Your speaker.
The Supreme Court has never said anything that raises any questions about the legality of the Clean Power Plan. In fact, the case that Professor Tribe mentions from 2011, the American Electric Power case, actually stands for exactly the opposite proposition. I mean, the Supreme Court decided to preempt federal common law claims because it said that EPA had the authority to regulate the emissions of the carbon dioxide emissions of plants under Section 111D. So the Supreme Court has not stood in the way of this kind of regulation. There isn't a single Supreme Court case that raises any constitutional question. As I indicated, non-delegation claim is not a serious one. The Supreme Court has never struck any federal statute down on these grounds since the mid-1930s. And here, all we have are two different conflicting approaches to a provision, and that's exactly what the agency gets the first crack at interpreting, and then the courts review the agency's interpretation, and that's actually already going on. There's been a challenge to the proposed rule that's now pending in the D.C. Circuit. It's going to be argued on April 16th, and in the standard way that these things are going to happen, the D.C. Circuit will decide whether the agency's interpretation is right or is wrong. But there's no real constitutional issue there. The takings claim, again, the Supreme Court, there isn't a single case that would support holding this to be a takings. If some firm thinks that it's been deprived of the whole value of its property through this regulation, which seems extremely unlikely, it can bring an action for compensation. If it in fact has been deprived of the value of its property, it will presumably prevail. But that's not a reason for striking down a nationwide rule. And on the 10th Amendment point, and I want to stress this because it's very important, the cooperative federalism model that's the core of the Clean Air Act provides for federal standards, gives the states an opportunity to come up with state implementation plans, and if they don't, the federal government can act and impose a federal implementation plan. This is the scheme under Sections 108 through 110 that the chairman mentioned. It's the way national ambient air quality standards are done in this country. These are the standards that have saved hundreds of thousands of lives. They're the most successful federal environmental program ever. And if Section 111D has the 10th Amendment problem that Professor Tribe ascribes to it, Section 109 would have exactly the same problem because it's exactly the same cooperative federalism model. And in fact, Section 111D uses pretty much the same language as Section 109. These are programs that have been around for 45 years. They were passed through a bipartisan consensus. They form the fabric of our environmental laws, and there's nothing different here than there is under Section 109.
Well, I was going to ask you about the 10th Amendment, but you sort of wandered into that, so I don't need to ask that question. So with that, I'll yield back the...
If I could say something about the unprecedented nature of this regulation that Professor Tribe and Ms. Wood alluded to. There's nothing of that sort. I mean, just last term, the Supreme Court upheld an important EPA rule that regulates the interstate emissions, where the statute says that it prohibits any source from emitting any air pollutant that will significantly contribute to environmental problems in downwind states. And EPA authorized states to adopt trading mechanisms that go beyond imposing controls on particular sources. This issue was litigated before the Supreme Court. Its opponents argued EPA didn't have the authority to do that because the statute referred to any source. And in the end, the Supreme Court upheld that regulation on a 6-2 vote with Justices Scalia and Thomas dissenting. So that's a very comparable program. It's also part of the same effort to control the emissions of existing power plants because they are such important contributors to pollution in this country.
Thank you, Mr. Chairman.
Gentleman yields back. This time I recognize the gentleman from Texas, Mr. Barton, for 5 minutes.
Thank you, Mr. Chairman. I don't normally reread parts of testimony, but I'm going to, in this case, read the some of the paragraphs of Professor Tribe because I think he lays out pretty explicitly and clearly what this is all about. This is at least his executive summary of his testimony today, and I quote, EPA lacks the statutory and constitutional authority to adopt its plan. The obscure section of the Clean Air Act that EPA invokes to support its breathtaking exercise of power, in fact, authorizes only regulating individual plants, and far from giving EPA the green light it claims, actually forbids what it seeks to do. Even if the Act could be stretched to usurp state sovereignty and confiscate business investments the EPA had previously encouraged, and in some cases mandated, as this plan does, the duty to avoid clashing with the 10th and 5th Amendments would prohibit such stretching. EPA possesses only the authority granted to it by the Congress. It lacks implied or inherent powers. Its gambit here raises serious questions under the separation of powers, Article 1 and Article 3, because EPA is attempting to exercise lawmaking power that belongs to Congress and judicial power that belongs to the federal courts. The absence of EPA legal authority in this case makes the Clean Power Plan quite literally a power grab. EPA is attempting an unconstitutional trifecta, usurping the prerogatives of the states, Congress, and the federal courts all at once. Burning the Constitution should not become part of our national energy policy. Now, that's pretty straightforward. Professor Tribe, I assume that we would stipulate that you're an expert in the Constitution. Is that fair to say?
Some people have said that.
Some people have said that. Okay. I would also assume that the committee can stipulate that you're an expert in regulatory authority or environmental issues. Is that also fair to say?
Again,
some people say that.
Some people say it.
Some people say that. Well, would you say, and again, I want to quote from another Supreme Court case. This is in the Supreme Court case back in 2001, Whitman versus the American Trucking Association, that Congress does not alter the fundamental details of a regulatory scheme in vague terms. It does not, one might say, hide elephants in a mouse hole. Would you say this is an attempt to hide an elephant in a mouse hole?
I would say, Mr. Chairman, that it's an attempt to hide a very large, constitutionally troubled elephant in a very tiny mouse hole, and not a mouse hole that was accurately described, I might add, by Professor Revesz. I mean, let me give you, if I might, just one example. He
Do it
talks
quickly,
about,
because I only have a minute and a half left.
well, he's just misdescribed the cases. The case of AEP versus Connecticut, he said Congress, that the Supreme Court said that the EPA has this power, except the majority opinion in footnote 7 said there's an exception. Under 111D, you can't use this power to regulate a source that's already being regulated under 112. Professor Revesz conveniently left out the only part of this case that's relevant. He also says that, well, I shouldn't take
Well,
time.
let me just reclaim my time. I was on the committee in 1990. I don't think Mr. Green was. I'm not sure anybody else currently here was on the committee. Was Mr. Pallone may have been? I'm not sure. But I participated in these debates. I was not on the conference committee between the House and the Senate, so I can't claim personal knowledge. But I was on the committee, and I was actively engaged in a bipartisan fashion in crafting this law. And we had a coalition of conservative Democrats like Billy Tozan and Ralph Hall and Mike Sinar on the Democrat side with the Republicans. And Mr. Dingell, who was chairman at the time, kind of played us back and forth. But there was never a debate in the committee that it would interpret the Clean Air Act amendments as the proponents of the Clean Power Rule. Never. It was never. Just the opposite. Just the opposite. And, Mr. Chairman, I hope after the conclusion of these hearings that we move legislation on a bipartisan basis that explicitly clarifies this point. The EPA has the right to set a national standard in interstate commerce to protect public health. It does not have the right to go in and micromanage how a state complies with a national standard, which, as I understand it, is exactly what this Clean Power Plan does. And with that, I yield back.
Thank you, Mr. Barton. At this time, I recognize the gentleman from New Jersey, Mr. Pallone, for 5 minutes.
Thank you, Mr. Chairman. I'm a little surprised by some of the legal arguments we're hearing against the Clean Power Plan, but I guess I've been around long enough to know that you can get constitutional lawyers and professors to say anything on both sides, just like I can get lawyers, at home to say anything on both sides. So I just wanted to give Professor Revis some time to comment on some of the comments that have been made by Professor Tribe. For instance, we're hearing that the Clean Air Act actually prohibits EPA from issuing the Clean Power Plan. However, the Supreme Court disagrees, citing American Electric Power versus the Connecticut case, if need be. An argument is also being made that since EPA acted to regulate mercury pollution from power plants, EPA does not have the authority to issue the Clean Power Plan. So, Professor Revis, is this argument a reasonable interpretation of the law?
No. Several things. First, on the American Electric Power case that we've now been arguing, there is footnote 7. I'm very familiar with it. Footnote 7 is subject to more than one interpretation. In fact, I'm holding the brief of the federal government in the D.C. Circuit case, and the federal government is interpreting this differently, the footnote differently. It's interpreting the footnote not to stand in the way of exactly what EPA is doing on the Clean Power Plan. Under standard techniques of statute interpretation, EPA, as the agency empowered by Congress to administer the statute, deserves deference. This is EPA's interpretation. EPA's interpretation is consistent with the argument I made, not with the argument Professor Tribe made. Now, Professor Tribe may in fact be ultimately right. That's for a court to decide. I believe that he is wrong. EPA believes that he is wrong. And we will find out. This issue will be argued extensively on April 16th before the D.C. Circuit. On the question about whether EPA cannot regulate under Section 111D because it's regulated mercury emissions under Section 112, that is wrong as well. There are two amendments. There's a House amendment and a Senate amendment. They were both passed. Now, it turns out that only one of them was included in the U.S. Code. That was a decision made by a mere functionary. This is the Office of Law of something or other, of Legislative Counsel. That person cannot supplant the will of Congress, and that's well established. So EPA has, for 25 years, under administrations of both parties, sought to give meaning to both the House amendment and the Senate amendment. The opponents would like us to ignore the Senate amendment entirely, and then would like to give the House amendment a particular gloss. And it's a gloss that involves rewriting the statute. The statute uses twice the word or, and they would like us to instead supplant the word and. The word and will be more convenient for them, but actually the statute has the word or. So not only would we have to ignore the Senate amendment, which there is no basis for doing, but we also would have to rewrite the House amendment, and we would have to go through an additional hurdle, which is not giving EPA the deference that it is due under traditional principles of statutory interpretation as embodied in the Chevron case. If I can make one related point on this analogy to cars, I don't think that the analogy to cars really works here, because in the car example that Ms. Wood referred to, the product is the car. And if EPA wants to regulate cars, it can regulate cars and regulate the emissions of cars, as it does and has done since the early 1970s. Here, the product is electricity. It's not electricity produced by coal-fired power plants. It's electricity. And as you know, we have an integrated system for delivering usable electricity to consumers. And EPA can figure out what the best system of emission reduction for delivering usable electricity to consumers is. Let me give you an example. When I was growing up in Argentina, where I was born, when I had a fever, my mother would give me a mercury thermometer. These things aren't sold in this country because they're dangerous, and instead we use digital thermometers. If using the logic of the opponents of the Clean Power Plan, the product would be a mercury thermometer as opposed to a thermometer, and therefore a regulation that might actually bring mercury thermometers out of business might be considered suspect. But we've never used a principle like this for regulation in this country for good reason, because doing so entrenches bad technologies and stands in the way of innovation. The product here is not electricity produced by coal-fired power plants, is usable electricity delivered to the consumer's home.
Thank you, Mr. Chairman.
Thank you. At this time, I recognize the gentleman from Texas, Mr. Olson, for 5 minutes.
I thank the chair and welcome Professor Tribe, Ms. Wood, and Professor Chavez. This hearing is about one document, this Constitution. I've had this in my pocket for over 2 decades now. It's kind of worn, comes out by pages, but it still is very much alive. And my first question is to you, Mrs. Wood. Under EPA's proposed Clean Power Plan, states would have only 13 months to develop their state plans. Is that 13 months by statute? If not, where does that mandate come from?
No, the 13 months is not from statute. The 13 months is just a deadline that EPA has come up with in this proposed rule. Under the applicable regulations, the deadline is actually 9 months for a state to submit its plan. But the regulations are very clear that EPA can extend that deadline as it sees fit, so it has wide discretion there. So it's actually extended it from 9 months to 13.
Wow, 4 more months. Now, correct me if I'm wrong, but other less complex programs, don't they allow usually 3 years to determine these standards? 3 years as opposed to 9 months or 13 months? Is that true?
Typically for state implementation plans, which are often called SIPs under the Section 110, the NAAQS program, states do get 3 years.
And this is for you, Mr. Tribe, as well as Ms. Wood. In light of the typical period for developing state implementation plans under NAAQS programs, does EPA's accelerated timeline in the Clean Power Plan for submitted state plans raise concerns? Constitutional concerns? Can you do it? Yes, no, reliable, whatever.
Are you asking whether the...
What are the concerns, sir? What raises these concerns with all this accelerated development going down from 3 years to 9 months to 13 months? What are your concerns? How about
honestly,
this document?
I don't know that the time change raises a big constitutional concern. But if I could, without cutting too much into your time, clarify one point,
your time, sir,
which I think is absolutely crucial to that little document that you're holding, and that is the suggestion that we should defer to EPA on which of the two versions of this law are really the law of the land. Let me be absolutely clear. It was not some functionary. It was the Senate conferees on October 27th, 1990, who said we recede to the House version. The Senate version couldn't be implemented because it was just a clerical thing that referred to something that no longer existed. So that is absolutely clear. This ghost version of the law that Professor Chavez wants to resurrect, and I don't know why he'd bother if the law, as it really is in the books, supported what they're doing, but I don't have time to go through the grammar to show why it doesn't. This ghost version doesn't exist. There may be ghosts, but this ghost is a non-existent one. And now what he's saying is that because courts generally defer to agencies like EPA, when they take a statute that's ambiguous and interpret it one way or another, it should also somehow follow that when Congress tosses a law into the air and there's another ghost competing with it, it's okay for the EPA to grab the ghost and run with it. What kind of version of the Constitution is he reading? Certainly not the one you've got in your pocket.
Yes, sir. I mean, I'm looking through this document. It has also the Declaration of Independence and the Constitution, 27 amendments. I don't see a ghost version anywhere in this document, so that's a great insight. My final question for all three witnesses. EPA has announced they will finalize its proposed Clean Power Plan for existing power plants this summer. Do you expect that final rule to be challenged in the courts? And will that be struck down or vacated, in your humble opinion?
Well, it's being challenged already in a particular case in the D.C. Circuit, but the problem is that that court might not reach the merits. It might say it's premature because, after all, we don't have a final rule yet. But the real dilemma is that states are confronted with not a ghost but a phantom. They're confronted with some federal alternative that they can't yet see. And so they're under enormous pressure, which is what makes this a violation of the 10th Amendment, under enormous pressure to revise their whole economy. And by the time that's happened, it might be too late for a court to unwind everything that's gone on. And, you know, maybe if that would have solved the whole climate problem, one would say, well, what's a little legal violation? But when you look at what the EPA itself says, it says that if this proposal were perfectly implemented and were not offset by what goes on abroad, what it would achieve by the year 2100 is at most reducing the rise of sea levels by 0.3 of a centimeter, which is like 2 or 3 sheets of paper, and reducing global mean temperature by under 1/100th of 1 degree centigrade. And I ask you, even if we could get all of that, is it worth that little document you're holding? And
Yes,
I'd
sir.
say no.
I'm out of my time. Thank you for being a Ghostbuster.
Gentleman's time has expired. At this time, I'll recognize the gentlelady from Florida, Ms. Castor, for 5 minutes.
Thank you, Mr. Chairman, and thank you to our esteemed panelists today. It's been very insightful. Professor Rivez, you have cited the Whitman versus American Trucking Association opinion as one of the most important environmental decisions overall in the history of the Supreme Court, and you say it has particular import for the Clean Power Plan. That was a case. Who was the author of that case?
Justice Scalia.
Justice Scalia. The central issue was the delegation of authority, whether it was constitutional or unconstitutional. Is that right?
That's correct.
So what did Justice Scalia say in that case that you think is quite analogous here and that might be an issue in future court cases?
Right. Thank you. So that was a case in which Professor Tribe wrote a brief arguing that the Clean Air Act was involved in unconstitutional delegation of legislative power to an administrative agency. Justice Scalia was widely regarded as, at the time, and still is, as the greatest friend of non-delegation doctrine in the Supreme Court. And Justice Scalia, writing for a unanimous court, rejected the non-delegation argument. It was rejected unanimously by a vote of 9-0. And that case is relevant to this situation because that was the last time that a broad non-delegation argument was made challenging a major environmental provision. It was a provision of the very same statute.
And that was the Clean Air Act, too, is that right?
The Clean Air Act as well, the very same statute. And Professor Tribe made his argument just like he's making it now, and it was unanimously rejected by the Supreme Court. If I can take just a moment to say something about ghosts. You know, I never knew that laws came in ghost and non-ghost versions. I mean, they're either laws or they're not laws. If they're passed by both chambers and signed by the President, they are laws. If they're not passed by both chambers and not signed by the President, they're not laws. Here, there was a House amendment and there was a Senate amendment. Both the House amendment and the Senate amendment were passed by both chambers, and they were signed by the President of the United States. That makes them a law. What the Senate manager said about receding would have been really interesting and very important if, in fact, they had carried out what they said and withdrawn the language. But the language was not withdrawn. It was passed by both bodies, and therefore it became a law, not a ghost law, a real law. And what EPA is asked to do here is not, as Professor Tribe said, to pick whether it likes the House amendment better than the Senate amendment. The question is whether these conflicting provisions of a federal statute can be properly reconciled. That is the business of an administrative agency. And an agency takes a first crack at doing that. EPA is not going to say, oh, we like the Senate amendment better. It's going to say, we think we can give meaning to both the House amendment and the Senate amendment. And if they do it appropriately, the courts will defer to their interpretation. And if they don't do it appropriately, the courts will strike it down. And that issue is now being litigated, as Professor Tribe noted, before the D.C. Circuit. It's going to get argued on April 16th. But certainly, that is the standard tool of statutory interpretation. That cannot, under any plausible guise, become a constitutional problem.
And if it was unconstitutional, what would happen to a whole range of environmental protection laws in America?
Well, I mean, if a court said that there was an unconstitutional delegation here because there were separate House and Senate amendments, and again, this would be it's hard to even imagine how that could be the case, given the history of the non-delegation doctrine in this country. Arguably, both provisions would be invalid, and arguably we would go back to the pre-existing law, which would be the 111D provision that was in the books before 1990, which would, I think, quite clearly give EPA the power to do exactly what it's doing here. So even if this was all right, it's not clear the remedy would help opponents of the Clean Power Plan at all.
Okay, thank you. I yield back my time.
Gentlelady yields back. This time recognize the gentleman from Illinois, Mr. Shimkus, for 5 minutes.
Thank you for all you smart people for being here. This has really been educational and enlightening, and unfortunately, it's going to have real consequences. So first, I was involved in a conference committee, the 2005 Energy Act, which was done here, open amendments, debated. And we don't do conference committees very much anymore. And so I think that's why there's confusion. So the first question is, if one chamber recedes to the other one, then the conference report has the language of the amendment that was accepted. There's no second amendment. Is that true, Professor Tribe?
Yeah, here...
Briefly.
No.
Thank you. Ms. Wood?
No.
Professor Reves, you seem to think there is. How can there be two amendments when you vote on a conference bill with language that has been given up by the Senate?
Because they both happen to statutes at large. Typically, if a chamber withdraws its amendment, it's
would
not
you?
passed by
But
both
the
bodies.
chamber did withdraw the amendment.
It did not.
Receded to it. Receded to the House language.
The House managers said that they were receding, but both amendments were passed by both chambers, and both amendments were signed by the President. That is not the standard situation where a manager...
It is standard. Excuse me. I don't mean to interrupt. It happens all the time. If Professor Reves's view were accepted, there would be sheer chaos, because this kind of situation...
You would have multiple definitions of the language that was supposedly passed by the legislative branch.
Right, and I'm not making a delegation argument here at all.
All right, thank you. I want to go to my second question. To Ms. Wood, Professor Reves talked about electricity in the interstate commerce and the regulated entity, where it's really... What is it? You tell me. I think I know what it is, but you tell me.
The confusion that you're rightfully experiencing is because he's convoluting that somehow the Clean Air Act regulates the product that's being sold, and that is absolutely not the case.
And the product in this case would be?
The product is electricity.
And what should they be doing?
But what is being regulated and what needs to be regulated is the electric generating unit, the piece of equipment that is generating electricity. And in my car example, the fact that the car, which is what is the emitting source, and the product is the same thing, just happens to be a coincidence. but what the Clean Air Act regulates are sources of air pollution.
Yeah, thank you. And I was following up on Congressman Olson's discussion on the 9 + 4 = 13 months. Where how long would judicial review take in a case like this? This is to Ms. Wood.
Typically in the D.C. Circuit, you would be looking at 1.5 to 2 years before you would get a decision.
So so that's the problem that a lot of us have. Okay, there's a constitutional debate and conflicting views. I think we've established that. But we're going to enforce standards on not just the utilities but the ratepayers before this decision gets rendered.
Indeed, and that's a very real problem, and you can see a very real-world example of it right now with the mercury and air toxics standards. That case is being argued next week before the Supreme Court, and a victory in that case is probably going to be hollow for many, many electric utilities because they have already installed the pollution controls under that rule.
And as we've had discussions here, the real-world implications of trying to comply financially. The difference between some of the Clean Air Act and sulfur dioxide was that we had technology to do it.
Yes, there were scrubbers that would remove the...
We knew the cost. They were, and this committee's been clear in our hearings that every process except for advanced oil recovery in a small facility in Canada is not financially doable. And the government's invested and actually pulled out of the Future Gen 2.0 because it's too expensive. This government has made a decision. They can't do it carbon sequestration.
There is another critical difference between this and the acid rain program that I think needs to be pointed out. The acid rain program was enacted by Congress. It was not done in a rulemaking by EPA.
Well, thank you. And I'll just end on this. Mercury thermometers are not dangerous, but breaking the thermometers and drinking the mercury might be hazardous to your health because I think everyone here, based upon our age, probably use mercury thermometers, and I yield back.
Thank you. At this time, I recognize the gentleman from Iowa, Mr. Loebsack, for 5 minutes.
Thank you, Mr. Chair. I'm a former college professor. I've really enjoyed this a lot, but but I'm not a constitutional law scholar. I did comparative politics and international politics, but I really do appreciate the back and forth and all the rest. But eventually we're going to have to make some decisions here as a legislative body. There's no question about that. Just one quick note. This isn't new in terms of the EPA. Taking it upon itself, if you will, or trying to implement some kind of legislation. I understand the arguments, just how far they're going, whether they're going too far or not. As you all know, long ago, Ted Lowy talked about how regulatory agencies often go much further than Congress ever intended them to go, and we're going to continue to debate whether the EPA is going too far or not. There's no question about that. In the meantime, I would. And Professor Tribe, if you would refrain from responding unless I ask you to do so. Professor Rivez, would you like to respond to Professor Tribe and his response to you on the 2 amendments issue? Just take a minute if you would.
Yes. I think as I've already said, it's often the case that there are conflicting House and Senate versions of bills, and in conference, the conference decides to go with one of the versions. That is the version that's then voted on by both chambers, signed by the president, and becomes law. That is the standard way that conferences work. Here, that's not what happened. It wasn't that there were conflicting House and Senate versions and the conferees chose the House version. The House version then became the bill that was voted on by both chambers and signed by the president. That's not what happened. What happened was that both the House version and the Senate version made it into the bills that were voted by both houses. They made it into the statutes of law at large. They were signed by the president, and they're both duly enacted law of the United States.
All right. Thank you, Professor Rivez. Professor Tribe, what is the legal way to address these problems? In your testimony, you mentioned the legal way to address these problems. What are we talking about when you say the legal way, and what are some examples of that?
It seems to me that an act of Congress or a series of congressional enactments is the only legal way. I mean, Congress has the power, did have the power to pass for the United States what California has done within California, a cap-and-trade plan, but it didn't succeed. Congress could fund alternative energy sources, put a huge amount of emphasis, as the government already is doing to some extent, on solar, on wind, on geothermal. But it really would take an act of Congress. It's just not enough for an agency to do it on its own. And here, even if there were, as Professor Rivez thinks, 2 laws that Congress did pass, assume he's right for the moment, and because both of them made it into the statutes at large, an agency would have to reconcile them, as he says. But you can follow both at once. That is, each of them precludes the EPA from regulating certain things. The Senate version focused on the pollutant. The House version focused on the source. You could obey both. There's no need to choose between them. And choosing between them is not an exercise of delegated power.
Well, you're someone who recognizes the importance of climate change, the reality of climate change. You said, and you have been.
I think
been environmentally minded over the years. If you could, you mentioned cap and trade. Are there other kinds of things that Congress could do?
Well, you know, if I were just to be very imaginative, and I'm only speaking for myself here, not for anybody else.
That's what I'm asking you to do, right?
A lot of people think that the best solution is to pay countries not to do so much deforestation, and that would take an expenditure of money. It's not the standard thing that comes to mind. It's way beyond the fence. But I think if Congress were able, I hate to say this, to get its act together, if Congress really could act effectively, there are a lot of things it could do. Now, there is a problem. A lot of my friends tell me, look, don't be an idealist, don't be utopian. Congress isn't going to do anything, so why are you so hot about the EPA violating the law and the Constitution? Well, that's just, I guess, the way I was brought up. I think the law and the Constitution matter.
Yeah, Professor Rivez?
Yeah, so under the Clean Air Act, Congress made a decision in 1970 not to define some limited number of pollutants that could be regulated, because Congress understood that as science evolved, other pollutants would become serious. And therefore, the Clean Air Act uses the term air pollutant. Typically, air pollutant endangers human health or welfare. EPA was basically required by the Supreme Court in Massachusetts versus EPA to acknowledge that greenhouse gases were air pollutants, subject to regulation under the Clean Air Act. This is not some power grab by this administration. This has been now a process that's been going on for almost 10 years, and the Supreme Court said yes. When Congress said air pollutants, it meant something pretty broad. There's a broad definition, and greenhouse gases are air pollutants. And then EPA was asked to determine whether greenhouse gases endangered public health, and actually the Bush EPA administrator made the initial endangerment determination. It didn't become effective at the end of the Bush administration, and then this administration made it again. And so now greenhouse gases are air pollutants endanger public health, and they're the core, and that makes them puts them at the core of what the Clean Air Act is designed to deal with.
Thanks to all of you, and thank you, Mr. Chair.
Gentleman's time has expired. At this time, I recognize the gentleman from Ohio, Mr. Latta, for 5 minutes.
Well, thank you, Mr. Chairman, and thank you very much for our witnesses today. We appreciate your testimony, and it is very informative. If I could start, Professor Tribe. Last year, the Supreme Court cautioned the EPA against interpreting the Clean Air Act in a way that would bring about an enormous and transformative expansion of the EPA's regulatory authority without clean congressional authorization. In your opinion, does the proposed Clean Power Plan comply with this directive?
I think that what the court said in the case that you're quoting, which was Utility Air Regulatory Group versus EPA, would apply many times over to this plan. And in particular, in that very case, the court addressed the point that Professor Rivez just made. Yes, air pollutant in the dictionary definition part of the Clean Air Act is a very broad term, and it does encompass greenhouse gases. But when the court in Mass v. EPA in 2007 found a specific provision for regulating greenhouse gases in connection with tailpipe emissions. What UARG, the decision last year, said is you can't rewrite clear statutory terms to extrapolate from the fact that something which is a greenhouse gas for purposes of a particular regulatory context can therefore be regulated under a different statutory provision, which it's very clear prohibits the regulation under 111D of greenhouse gases or any other air pollutant from a source that has already been forced to spend a lot of money under 112 in order to meet the requirements of 112 with respect to the 188 hazardous air pollutants.
Okay, Professor Tribe also then, the Clean Air Act places limits on the EPA's authority to use the Section 111D to regulate existing sources that are already subject to regulation for hazardous air emissions under Section 112. Does this prohibit the EPA from regulating coal-fired utilities under Section 111D?
From regulating, I'm sorry, I didn't hear what kind of utilities?
From regulating coal-fired utilities
under 111D. It certainly prohibits them as long as those utilities are being regulated under 112. For the hazardous pollutants, greenhouse gases cannot be regulated under 111.
Well, with that then, especially from the testimony I've been hearing this morning, should the EPA's interpretation of these statutory provisions be entitled to deference by the courts? And if not, why not?
Well, two reasons. First of all, what it's doing is not interpretation, it's revision. It's picking a statute that Congress did not enact. And that is not something to which the courts would ever defer. Secondly, the principle of deference under a case called Chevron only kicks in where there is an ambiguity, and here there isn't an ambiguity. And besides, deference is trumped by a principle called constitutional avoidance. That is, the Supreme Court has said, and the D.C. Circuit has said, that when an ambiguous statute, and I maintain this is not ambiguous, would cause constitutional problems if you defer to the agency's interpretation of it, then you don't defer. So that even if deference were otherwise available, here it would be trumped by the serious constitutional problems that I've outlined. Haven't had time to talk about in detail, but my statement in written form explains why, for example, even though the property is not being totally destroyed, this is a violation of the Fifth Amendment, and explains a number of other things. So given those constitutional problems, which I don't think have been solved,
and not picking you, Professor Tribe, if I can just follow up with one question here because I'm short on time. The Clean Air Act as a whole and Section 111D in particular are based on principles of cooperative federalism and are designed to give states autonomy and flexibility in implementing emission control programs. Does the proposed rule strike an appropriate balance between the EPA and the states?
I think that the EPA is not striking a constitutionally appropriate balance. It's basically saying, yeah, you have some choices to meet this severe limit, but it's like saying your money or your life, and you can choose whether to pay me in cash or by check or by Bitcoin. That is, there is no power to command the states to do any of this stuff. And saying that, well, this is just optional, it's like cooperative federalism, completely confuses what happens normally under the Clean Air Act with what is happening here. Normally, a national goal is set, and the federal government works with the states to find a way to implement it locally. That's not what's going on here. What's going on here is radically different.
Thank you. Mr. Chairman, my time's expired.
Gentleman's time has expired. At this time, I recognize the gentleman from Texas, Mr. Green, for 5 minutes.
Thank you, Mr. Chairman and Ranking Member, for holding here, and I want to thank both our panels of witnesses to be here today. I know there's some disagreements about the EPA Clean Power Plan, but as a lawyer, I'm always interested in hearing the arguments from our professors. Besides this hearing, the EPA Clean Power Plan has been subject to a lot of debate. Whether EPA has the authority to regulate power plants will ultimately be decided by the courts, and it's this issue I find most disappointing. I've been in Congress for some time, and I would like to see a solution on our climate issues offered by this body, and not necessarily because of the Supreme Court ruling. We should work together and control carbon emissions. That doesn't mean eliminating traditional fuels, and it certainly doesn't mean dismantling the EPA. It means a reasonable approach from a legislative body that would require compromise, and that's what we've been sent here to do, and I look forward to both panels. Professor Tribe, your testimony, the portion that jumped out at me was on page 11, where you stated it makes far more sense to address climate change by legislation. I couldn't agree with you more, but without congressional action, the federal agencies have acting under the existing authority given by the Supreme Court. Professor Tribe, in your testimony on page 14, you addressed EPA's reference to the Chevron USA case. It's my understanding Chevron created a two-part test to determine regulatory authority. There are many attorneys in Washington and D.C. around the country making large sums of money advising clients on which version of the House or Senate amendment to the Clean Air Act or law. If the Supreme Court agrees to hear this case, is it your argument that Congress spoke directly to the question at issue, or do you believe the court will rule on the agency's interpretation?
Well, I don't think the court would accept the agency's interpretation. I think here the statute is too clear, and the court in the UARG case made as clear as it could possibly have made it that the fact that greenhouse gases may be a terrible problem doesn't give a blank check to any agency to rewrite the law.
If I can interject for a minute, I mean, in that case, EPA was trying to regulate 86% of the greenhouse gas, of the carbon dioxide emissions of certain stationary sources. The court, in that case, allowed EPA to regulate 83% of those emissions. Justice Scalia indicates that in his opinion. It only deprived EPA of the authority to regulate the last 3%, and that was because that statute had a particularly had a specific numerical provision that would have required EPA to either regulate a much larger number of sources than EPA wanted to do, or else disregard the number. And as a result of that problem, the Supreme Court deprived EPA of the authority to regulate the last 3% of those emissions, but allowed EPA to regulate 83% of the emissions of these stationary sources. So EPA ended up getting most of what it sought, the vast majority of what it sought out of that case. And the problem, the statutory problem that arose was a very specific statutory problem under that particular provision that has no bearing on other provisions that don't have those numerical limits.
Professor Riz, one of the other things, since I've only got a minute and a half, would a strict reading of the House version exclude many, if not all, potential regulated sources? And do you have written extensively on environmental law and regulatory policy? Is Congress, while we don't interpret the law, it's our job and the courts do that. We have the responsibility for conflicting issues in the laws that we wrote. Do you agree with that?
Absolutely. And it often happens. I mean, you know, this isn't an example of Congress doing something wrong. I mean, it often is the case that statutes get passed and they have ambiguous provisions that require agency interpretation. This is the bread and butter of what the federal courts then do, is to determine whether the agency interpretations are entitled to deference and whether they should be upheld.
And that's the federal court's job. Let me give you an example of one of the legislation that we've worked on passing. Congressman Olson and Congressman Mike Doyle and I have introduced legislation, and it's actually passed the House, to resolve conflicting language in the Federal Power Act. And that's our job, to be able to do that, to do the legislating if there's an issue that the courts may not be addressing, in our opinion, is what the law is. Professor Tribe, I'm sorry I don't give you any more than 10 seconds. But
well, I agree with that allocation of responsibility. I also think that measuring the law by percentages is not exactly right. I saw those talking points too.
Yeah.
You know, the EPA wanted to win, and they said, why don't you point out we won 83 rather than 86? That wasn't the point. The point was that their approach to the law was totally rejected by the court.
No, there were two issues. EPA won on one issue and lost on one issue. It was not totally rejected by the court.
Gentleman's time has expired.
Thank you, Mr. Chairman.
This time I recognize the gentleman from West Virginia, Mr. McKinley, for 5 minutes.
Thank you, Mr. Chairman, and thank you, the panel, for being here. It's always enlightening to hear some of these discussions. I know ultimately the decisions can be made by the courts, but it helps us to understand a little bit of these issues, particularly between 112 and 111D. But I don't think the American public gives a hoot. They really don't. They just want to make sure that Johnny has a job and their electric rates are going to be reasonable for them to be able to continue. And I see us getting caught up. We start chasing these rabbits that get us distracted from where we need to be. I'll be the first to tell you that do I think climate change is occurring? Absolutely. I think it is. But we've taken this simplistic route to go this direction. So what I want to do is get back more to the fundamental. You all were chasing this rabbit all the way down. You're arguing over 112 and 111D, and you're talking about phantoms and ghosts. I think don't care. What are we going to do? What are we doing here with this fight? I'd like to get back to the more basic where we are, because under the United Nations has said that 96% of the CO2 emissions are naturally occurring. Only 4% of all the CO2 emissions of the world are anthropogenic, man-made. See, I can use the term like you all did. Only 4%. And then they go on, the United Nations goes on to say that all coal-fired powerhouses in America, if you shut off terminated a coal-fired power, every one of them shut down in America under the United Nations, said you only reduce the CO2 emissions by 0.2%. That's not my statistic. That's from the United Nations. 0.2%. So what I'm doing, I'm the engineer in the room here on this. So now we're getting to the point, under this rule, they want to reduce it 30%. So we're talking about a rule that reduces 30% of 0.2%. We're talking about a reduction of CO2 emissions in the globe of 0.06%. Forget the argument over 112 or 111. We're going to spend billions of dollars. We're going to raise rates. Jobs are going to be lost to save 0.06% of the CO2 emissions. That doesn't make logical sense. From an engineering perspective, there's something wrong when we start chasing a rabbit over here, when we're putting our economy at risk over 0.06%. Professor, could you respond to that? Are we chasing the right rabbit here?
Well, my grandchildren ask a similar question, which shows how wise you are, because I think my grandchildren are smart as whips. Grandpa, why are you worried about this 111, 112 stuff? Is the world going to be destroyed? And then I tell them, well, there is this agency, and it says if you do what it wants, they're not going to save the world. In fact, maybe by the year 2100, they'll prevent the oceans from rising as much as, well, 2 sheets of your paper. But they think that by making a start, it's good, better than nothing. Well, you know, your grandpa spends his life teaching about the Constitution, and so I sort of put that in the balance. That's part of, you know, there are a lot of details there. They look like rabbits going into rabbit holes, but that matters, because in the long run, all those rabbits add up to something that this country has built. And then they ask a different question. They say, well, if we make a start, isn't that good? And then I try to give them the old proverb, you can't leap across a chasm in 2 steps. You know, jumping halfway or even 1% of the way might do a lot more harm, like you splat on the bottom of the chasm, than not doing this at all and looking for something else. But what would you do, Grandpa? And then I say, I'm not an expert in that stuff.
Ms. Woods?
I wanted just to expand for a second on what Professor Tribe was saying about, you know, needing to make a start and wanting to build on something. I think it's important to recognize here that if these sources are not regulated under Section 111D, They are regulated under Section 112, and that's what is prohibiting the 111D. Under 112, these sources have to put on maximum available control technology, maximum. So it's not as though these sources are not going to be controlled. And more importantly, in terms of when you start talking about carbon dioxide, I think it's also important to note that EPA has said that the carbon benefits from that maximum available control technology are estimated to be $360 million annually. So it is not as though there isn't a start being made.
Well, and my time's running, but I'd rather us be focusing on something more practical than this ideological. Why aren't we doing energy efficiency? Why aren't we looking at more research into clean coal technology? But to simply go after it and start doing this and costing us jobs, I think is incredibly naive. Thank you, and I yield back.
Gentleman's time has expired. At this time, I recognize the gentleman from Kentucky, Mr. Yarmouth, for 5 minutes.
Thank you very much, Mr. Chairman. Thanks to the witnesses. After listening to this discussion, I'm not sure I'm happy or sad that I dropped out of law school years ago. I think I'm happy. But I want to go back to you mentioned the Massachusetts versus EPA case, and when we were debating the Waxman-Markey bill several years ago, 2009 and so forth, that was kind of the motivating factor, I think, for many of us at that point, that if the Supreme Court had said that we have to regulate carbon dioxide, wouldn't it be better for Congress to act and create a mechanism for dealing with it than trusting the EPA to be flexible enough to deal with states like my own and Congressman McKinley's as well. So I'm curious because I've heard some difference of opinion, and I don't want to start another debate, on whether that decision actually made it compulsory for EPA to regulate CO2 or just basically made it permissive. Do you deal with that? You're shaking your head, Ms. Wood. You want to answer that? Oh, give me the one.
Yeah, that decision held that EPA in that case was arguing that greenhouse gases were not air pollutants for the purpose of Section 202 of the Clean Air Act. The Supreme Court held that they were, in fact, air pollutants for the purpose of Section 202 of the Clean Air Act. It did not mandate regulation because regulation is mandated only if the air pollutants endanger public health or welfare. So EPA, the next step was for EPA to make the determination. The court did not make it, as was appropriate, to make the determination whether greenhouse gases endanger public health and welfare, which is a statutory term. As I indicated earlier, Stephen Johnson, who was the EPA administrator at the end of the Bush administration, made that endangerment finding, but it didn't get the administration ran out of time. It wasn't approved during the Bush administration, and it was therefore made anew by the Obama administration. So now, and that was challenged in the D.C. Circuit. Many groups challenged the endangerment finding and said that that the agency had acted inappropriately in making that finding. The D.C. Circuit upheld the agency's decision. Those same groups then petitioned the court for certiorari. And the court, while granting cert on other issues in that case, and that ended up being the Utility Air Regulatory Group case, denied certiorari on the endangerment finding. So now it basically is the law, or at least it's the agency has said that greenhouse gas emissions endanger public health. Now, Massachusetts EPA dealt with Section 202 of the Clean Air Act. The definition of air pollutant and of harming public health is very similar across many sections of the Clean Air Act. And therefore, that case has now led to all these other rules. These rules are basically based on exactly the same legal principle. And EPA is proceeding accordingly with the Supreme Court's blessing.
They're doing their job as they see it based on what the Supreme Court said about CO2.
What the Supreme Court said in Massachusetts EPA that greenhouse gases are air pollutants, what the D.C. Circuit said in the case that became UARC in the Supreme Court that they endanger public health. And then,
in fact, there has been a considerable amount of at least scientific evidence that there is a connection between CO2 and elevated levels of asthma and so forth in communities. I know that's true in my community as well. I want to get to a question real quick with Ms. Wood. in your issue about whether or not we regulate the product or go outside the fence or so forth, if under a state's plan, the state utilities, power companies, offered financial incentives for conservation to its customers, would that fit within your conclusion of being something that would be consistent with your interpretation of what EPA can regulate? Even though in this case it would be voluntary. I mean, the states would be doing it, not EPA, but EPA would have to approve the plan.
I think the key difference here is in how the targets are set versus the flexibility that you could use to meet that target. And I think this is a key distinction that needs to be made. And the issue isn't whether a power company could do what you're saying to meet the target. The question is, should those types of things be considered in determining what the target is? And to that, my answer is no. The Clean Air Act doesn't permit that. 111 has always been understood to begin and end at the source. Now, in the Clean Air Mercury rule that EPA did several years ago, they did have flexible cap and trade mechanism to meet that limit. But the target itself and the limit itself was based on technology that could be applied at every unit. So you started with activated carbon injection and you figured out what the rate would be at each unit, but then you allowed flexibility in terms of how you would meet that. So in your example, I think that would be permissible in terms of meeting the target, but it would not be permissible for setting the target.
Okay. Appreciate that. I yield back. Thank you.
The gentleman yields back. This time recognize the gentleman from Virginia, Mr. Griffith, for 5 minutes.
Thank you, Mr. Chairman. Appreciate you having this hearing very much. I rarely disagree with my colleague from West Virginia, but in this case I do. The process and the procedures by which we get our laws and pass our laws may not always make sense or be practical in the minds of some, but it is what has allowed our republic to exist for the length of time it has, over 200 and I guess we're closing on 220 some plus years, and it is extremely important. Professor Rivez, I love these things, and I'm going to go down a different rabbit hole than the one we've been going over, although I'm coming back to that one because I love that one too. The proposal that you make is a parliamentary procedure impossibility. It cannot happen. It doesn't matter what the issue is. Jefferson's very clear in the Manual of Parliamentary Practice. When there are differences between the two houses, they get together in a conference and they work those differences out. If both houses adhere to their position, the bill itself dies. It's not for you to say today that the bill should die if there's some confusion because there are two different versions. There are not two different versions. There is one version. It could not have passed out of both houses, gone through a conference committee, and gotten to the President's desk unless there was one version and one version exclusively. And then we get to the point that Professor Tribe made, and it is an honor for me to be in your presence. We're not always going to agree. There's a lot of things we're going to disagree on politically, but your defense of the Constitution, I'm 100% behind and agree. And even when the rules in the Constitution are against me on what I believe ought to happen, I respect that those bodies and those rulings must be followed. And so we get to that because I think that if there was some kind of a disagreement and suddenly it's found 25, 30 years later, that creates a problem. And I would submit, I don't know about the 1995 ruling, and I would ask you quickly if you could tell me about that. You said that it had already been determined in 95, 8, and 11, and I know 8 and 11.
Right. Well, in 1995, the EPA itself interpreted the Section 111D as I have, and as I think the courts would.
Okay. And then we get to 2008, and you didn't make this point, although I'm sure you're aware of it, and I find this language fascinating. It brought this up to the EPA months ago. That decision, if you read it, part of it says, this requires vacation of cameras regulations for both new and existing EGUs, electric generation units. EPA promulgated the camera regulations for existing EGUs under Section 111D. This is a court opinion by the circuit court in D.C. Listen to what I'm saying here. for existing EGUs under Section 111D, but under EPA's own interpretation of the section, it cannot be used to regulate sources listed under 112.
Right.
The judge found that they had conceded, and he goes on to say, EPA thus concedes that if EGUs remain listed under Section 112, as we hold, then the CAMA regulations for existing sources must fail. The EPA appealed that ruling, but not on that point. Now, what's significant about that, and the question I have for you, and I'm going back to first-year law school for myself, is the EPA now precluded under either the theory of res judicata or collateral estoppel, having conceded the point in the 2008 case and not appealed at the Supreme Court, and having been a party in that case, albeit not a party in the 2011 case, have they conceded the point, and are they now thrown out on their backsides because they've already conceded this point, and to bring it back up is a waste of time, as Mr. McKinley said?
I think because that case was New Jersey v. EPA, it's only New Jersey that could make that collateral estoppel argument. Other people confronted by an EPA that says, we have now changed our minds, like Robert Jackson once said, the matter does not appear to me now as it appears to have appeared to me then. Other people are not going to be able to stop the EPA.
But I would
so
point
the
out,
EPA is free to make these arguments. I just think they're wrong and will lose.
all right. And you think they will lose also in looking at 2011, although they were not a party to that. You were correct in referencing footnote 7 that said that the Supreme Court specifically said in their opinion, previously cited approvingly by Professor Rivez, that there is an exception. EPA may not employ 7411D, which is what we're talking about, if existing statutory sources of the pollutant in question are regulated under the National Ambient Air Quality Standard Program 74087 through 74110, or the Hazardous Air Pollutants Program 74112, which is what we're talking about is 111 and 112. Am I not correct?
Correct. And that use of the word or supports the court's reading. The courts have been consistent in accepting this reading all this time. And it is amazing, though it's not illegal as such, for the EPA to scratch its head and say, how are we going to win this case? We got to invent a new statute.
And they've reached pretty deep to find something that they could hang their hat on.
They reached very deep to something that Senator Durenberger, when it was first proposed, said, I can't imagine this being used very often. It's only been used 5 times. It's a technical little, well, it's a mouse hole, and they're pulling an elephant out of it.
Thank you. I have to yield back. I wish I had more time.
Gentleman yields back. Thank you. At this time, recognize the gentleman from Maryland, Mr. Sarbanes, for 5 minutes.
Thank you, Mr. Chairman. Thanks to the panel. I don't know that I have a whole lot to add or more to ask, but we've talked about phantoms and we've talked about ghosts, and we're now getting to a dead horse in terms of beating it over this issue of the interpretation. I gather that the crux of this is whether the EPA's pursuit of the Clean Power Plan is warranted or authorized under Section 111D, and that then gets to this question of whether it's seeking to balance and interpret the conflict between these two amendments as appropriate or not appropriate. Because you all have been debating this most of the time we've been here, I'm assuming that while there's other parts of your argument and briefs that you point to, that you view that as probably being the issue upon which a court's review of this question is going to turn. Is that fair?
Well, I've tried to encapsulate the essence of it, but it is what I submitted is over a 50-page document, and I do think courts will pay attention to the several different parts of the argument. One, that even if Congress did give this power to the EPA, it would violate basic principles of federalism, and that's one reason that a court would not interpret Congress as having done so. 2, that there are powerful issues about the statute itself and the EPA's authority to go beyond a statute. And 3, separation of powers issues that arise out of the EPA's recognition that because the statute as written doesn't quite do what they want to do, they've created a magical mystery tour through the parliamentary procedure to say, well, there are two statutes. And although I've suggested, both here and in my written testimony, that if there really were two, which doesn't happen, they could follow them both by both outlawing the regulation of pollutants that are covered by 112 and outlawing the regulation under 111D of sources under 112.
Professor,
if I can answer your question more directly, the debate we've been having here is replicated in hundreds of pages of briefs before the D.C. Circuit. All of these issues are being aired in great detail on both sides. The position that most of the positions that I've made here are made by the U.S. Department of Justice, by many states. Other states are taking the opposite position. Some industry groups are agreeing with my interpretation of the Constitution of the statute. Other industry groups are on the other side. All of this, there are hundreds and hundreds of pages of briefs on all of the issues we've been talking about. If I can just take a moment to respond to an issue that Mr. Griffith raised, there's clearly only one version of the statute. There has to be only one version. That one version includes arguably inconsistent provisions. They're arguably consistent, they're arguably inconsistent. But they were both voted on by both chambers and signed by the President. In the Camera case is different, because in the Camera case the problem was that EPA had initially sought to regulate mercury emissions under Section 112. Then in the Bush administration decided to regulate under Section 111D, but it was trying to regulate the same mercury emissions, the same hazardous air pollutant. Everyone concedes that EPA cannot invoke Section 111D to regulate a hazardous air pollutant that's being regulated under Section 112. But here the issue is that greenhouse gases are not hazardous air pollutants regulated under Section 112. So the Camera case is actually inapposite to this problem. But I'm sorry, I took up a little bit of your time.
No, actually, that was I was going to ask you to add whatever you think is left on this question. Can you real briefly in 43 seconds just give me a little bit more of your perspective on why the takings issue is not determinative here?
Well, because first, this is a regulation. It's not a physical taking. So a regulation would have to deprive a property owner of almost all of the value of the property. And also, if there is a property owner for whom that is the case, the proper remedy is not to invalidate this regulation, but is for that property owner to sue separately at a later time for compensation.
Thank you.
Could I add
Sure, Professor Tribe, you've got
one word.
a few more seconds.
We've never suggested striking down the law. Compensation is all we've talked about. But ever since the steel seizure case, the Supreme Court has said that an agency and that even the president is not allowed to impose a bill on the American taxpayers for compensation unless Congress, which has the power of the purse, has clearly authorized the action that is going to require the compensation. That's all we've been talking about under that part of our argument.
But there's no compensation required here. And on one last point, on footnote 7, as we've now, I think, indicated, footnote 7 is subject to interpretations. And there are literally dozens of pages in the D.C. Circuit briefs on either side of that issue. I think it's pretty clear what footnote 7 means. Obviously, Professor Tribe thinks it's clear on the other side, but there are two interpretations of footnote 7 of the American Electric Power case that are out there.
Thank you. Gentlemen's time has expired. This time I recognize the gentleman from Missouri, Mr. Long, for 5 minutes.
Thank you, Mr. Chairman, and thank you all for being here today. When we started this hearing, I didn't have this document in my hand. And I represent the 7th District in Missouri, which is Springfield, Joplin, Branson, Missouri. And we've got a lot of successful businesses that germinated there. Bass Pro Shop started from nothing and has become what it is today. O'Reilly Automotive, which is across the United States, very successful company. We have a great medical community there, a lot of successful businesses, and a lot of people that just want to raise their kids in a good part of the country. Have a good job, raise their kids, have a nice place to raise their family. And I saw in my notes today, my little handy-dandy pocket card here, that city of Springfield was coming to see me today, and I thought that's great. They think enough of me to come and talk to me about some issues that they have pressing. I'm glad they came to Washington to see me, but they didn't come to Washington to see me. They came for a conference. And the reason they came to this conference, there were 2 cities in the United States that were invited to the conference to speak on this. One was Richmond, Virginia. The other was Springfield, Missouri. And the reason is they have done such a good job, such a forward-thinking job with these different issues that we're discussing here today. I want to read you just a little snippet of what we have and then kind of ask your all suggestion on something. But this is from Mayor Bob Stevens, Mayor of Springfield, Missouri. Affordability and unfunded environmental mandates. Now, like I say, you can think what you want about things, but I stepped off in the side room here and got this at our meeting. I couldn't run back to my office and meet him over there, so I was required to meet him here due to time constraints. Affordability and unfunded environmental mandates. As you know, the city of Springfield, Greene County, and Springfield City Utilities have been working cooperatively to develop a proposed integrated plan framework that would foster a more holistic approach to the various unfunded EPA environmental mandates that all communities are facing: wastewater, stormwater, drinking water, air quality, and solid waste. Our integrated plan framework attempts to consider all of these issues together instead of each one separately, and to focus resources where the community can achieve the biggest bang for the buck. We appreciate your efforts to ensure that future unfunded environmental mandates must be affordable for the community and the citizens. Now, one of the things that they did in this report that they're in here in Washington, and we're honored enough to be thought of highly enough by the conference to be one of 2 cities, is they did the math. I know you all are constitutional scholars and such, but I don't know how your math is, but the math that they did was over the next 15 to 20 years, these unfunded mandates from the Environmental Protection Agency are only going to cost each individual in my district a little over $46,000 per person over the next 15 to 20 years. So I guess I'll start here with Professor, is it Rivas? Do you have any suggestions what I tell the folks back home about these?
Well, it's a little hard for me to comment on a document that I haven't seen, but I can tell you from my experience, one of my areas of expertise is the cost-benefit analysis of environmental regulation, and I actually care a lot about having the benefits of environmental regulation exceed the cost, and I'm a big proponent of the use of cost-benefit analysis to justify environmental regulation, which sets me apart from actually the vast majority of environmental law professors in this country who don't like it as much as I do. But I can tell you that often these early cost estimates turn out not to be accurate. And
they're usually low, aren't they?
No, actually, empirical studies show that initial cost estimates tend to be higher than the ultimate costs are, and there's a good reason for that. Initial estimates are generally made on the basis of sort of current end-of-the-pipe technology, but there's a great ingenuity in American business, and businesses figure out ways of doing things more effectively and more cheaply, and for that reason, in the end, costs end up being lower than are predicted. There's a lot of debate on cost estimates. There's huge variance. And each of those estimates should be submitted to serious peer review by serious experts, and I would take well-conducted cost estimates very seriously. But I would caution.
And I hate to interrupt you, I'm about out of time, but Johnny Morris, the owner of Bass Pro Shops, has a saying: we all live downstream. And we all do live downstream. We want to have a clean environment to raise our family in, whether it's in the Ozarks or Washington, D.C., or the state of Washington. We all want a good, clean environment. But unless you own Bass Pro Shops or you own O'Reilly Automotive or one of these businesses, and our median income is under the $46,000 a year, it's pretty tough to explain to the folks back home that you got to put a cup in the storm waters that passes through Springfield and dip it and make it palatable in some of these ridiculous regulations. I think I'm over my time. I was going to yield some time back, but I don't have any, Mr. Chairman. Thank you.
The gentleman yields back. At this time, recognize the gentleman from New York, Mr. Tonko, for 5 minutes.
Thank you, Mr. Chair, and welcome to our panelists. Since 1970, the Clean Air Act has had several key features that have helped make it one of the most successful environmental laws in the world. Science-based, health protective standards keep our eye on the prize: healthy air for everyone. Cooperative federalism allows EPA to set the clean air goals and allows states to decide how best to achieve them. EPA retains backstop enforcement authority, ensuring that every citizen of the United States receives a minimum level of protection even if their state fails to act. Some have claimed this arrangement violates the 10th Amendment, and I quote, if a state fails to formulate a plan, EPA will mandate a federal plan. This commandeering violates the Constitution under New York versus U.S., close quote. Professor Rivers, does the Clean Air Act's state plan, federal plan provisions violate the Constitution?
It does not. And the reason is that states are not required to do anything. States are given the option to come up with state implementation plans, and if they don't, EPA can impose federal implementation plans on the sources of pollution. And because EPA imposes those directly on the pollution sources and not on state institutions, there is no 10th Amendment problem. The cooperative federalism arrangement under Section 111D, as I indicated earlier, is exactly the same arrangement that has been in place since 1970 for meeting the National Ambient Air Quality Standards. EPA sets the reduction requirements in the National Ambient Air Quality Standards that define the maximum permissible concentration of pollution in the ambient air. The states can then decide how to allocate that reduction requirement among their sources through state implementation plans. And generally they do, but sometimes they don't. And when they don't, EPA imposes federal implementation plans. And this system has been going on for decades. The reason there isn't the 10th Amendment problem is because EPA does not actually require the states to do these state implementation plans. It merely gives them the option to do them. And 111D is exactly the same situation. Through the Clean Power Plan, the proposed rule in the Clean Power Plan, EPA has set a reduction requirement that applies to each state. Each state can now decide what to do. Each state is not forced in any way to do what EPA has suggested they do in the regulation. They do whatever they want as long as they meet the reduction requirement. And if they choose not to do anything, as some states have said they won't, EPA can then impose a federal implementation plan. And the fact that some states have already said that they will not do it shows that there's no compulsion.
Professor, would it be fair to say that and I quote, the existence of a backup federal plan takes the Clean Air Act outside the commandeering world, just as the Supreme Court said in the radiation case of New York versus U.S.?
Yes, that's exactly right. And the New York case was problematic because there the federal statute was requiring states to either take title of certain waste or adopt certain regulations.
Well,
that is not the case here.
Thank you. And I ask about these two statements because they were both made by Professor Tribe, and I sensed a bit of conflict there. Do you see any conflict in the two statements, between the two statements?
Well, there certainly is conflict between the two statements you mentioned now and Professor Tribe's position in his written submissions and in his testimony today.
Thank you. And Professor Rivers, we're all hearing all these. We're hearing about these legal questions about the EPA's ability to regulate greenhouse gases emitted from power plants. As you know, power plants are the largest source of uncontrolled CO2 emissions in the U.S. I'm not an attorney, but I thought the overall question of whether EPA had the authority under the Clean Air Act to regulate greenhouse gases was considered by the Supreme Court. I believe there were three separate cases: Massachusetts versus EPA, American Electric Power versus EPA, and Utility Air Regulatory Group versus EPA, and that the court ruled in favor of EPA regulation of greenhouse gases. In fact, the court in the Utility Air Regulatory Group case, talking about EPA regulation of power plants, said that, and I quote, "The Act speaks directly to emissions of carbon dioxide from the defendant's plants," close quote. So I just thought we should remember that and put it all in context. And any comments that you have in regard to those cases?
I totally agree. In the Utility Air Regulatory Group case that was decided last year, one of the issues was whether best available control technology could include the regulation of greenhouse gases, and the Supreme Court held that it could. And the reason that it could is because greenhouse gases were regulated air pollutants that endangered public health and welfare.
Thank you very much. With that, I see my time is up, and I yield back.
The gentleman's time has expired. I know that Mr. Tribe was trying to respond. Did you want to make a comment?
Right. I don't know whether you call it a point of personal privilege or whatever, but since I was quoted, the context was a statement I made in October of 2012. I was talking about something that bears no resemblance to the plan that was proposed by the EPA on September 2014. I may have some ability to foresee the future, but not that much. It is true that the existence of an otherwise unproblematic backup plan can take something out of the normal commandeering world. But here we have something that is much more like what the U.S. Supreme Court decided in NFIB versus Sebelius was impermissible pressure on the states, because pre-existing help that the states are getting from the federal government to deal with air pollution in places like Springfield can be yanked when the state is recalcitrant and does not succumb to the federal government's demand that it meet certain goals. In addition, the backup plan here, the reason I called it a phantom earlier, is something that Professor Rivez said at page 13 of his prepared statement. He says, it remains to be seen what a backstop federal implementation plan will look like. Now, what kind of alternative is it to tell a state, you either achieve these goals, and you can do it in any of several ways, but none of them are voluntary, or we'll do something to you and we won't tell you quite what. Okay. It's not just putting a bullet to their head, it's making them play Russian roulette.
Thank you, Mr. Tribe. You want a personal privilege, Professor?
Yes, I would like that. That's the way that the Clean Air Act has worked for 45 years. Under the National Air Quality Standards, EPA can set state implementation plans. If they don't, the federal government can impose a federal implementation plan. The federal government does not say up front what that federal implementation plan would look like. Wow. It waits until the states either submit a state implementation plan or not. Here, EPA is actually doing something it has never done before, which is favorable to the states. It's basically said, we're going to give you early guidance, and we're going to do it sometime in the next few months, so you actually have some information, which is a lot more information than states have had under the kind of bread and butter of the Clean Air Act for the last 45 years.
And we have another panel coming up after you all that will be getting into this also. This time I'd like to recognize the gentlelady from North Carolina, Ms. Elmers, for 5 minutes.
Thank you, Mr. Chairman, and thank you to our panelists for being here today on this subject. I'd like to, focus in, we are talking about our states. And in North Carolina is going to be negatively impacted by the increased utility bills. I know we've already discussed whether or not that will take place over time, but as it plays out, I do believe that will be the case. And obviously this interpretation of Section 111D of the Clean Air Act. With that, I would like to ask Professor Tribe and Ms. Wood, the EPA maintains that the rule is very flexible. How would you describe the rule in just a few words? Because I know we've kind of gone over this subject a bit, and I have a very particular question I'd like to ask all of you in the remainder of my time.
Well, I would say that the flexibility is an illusion. In fact, the Attorney General of Michigan, in comments filed with the EPA in November of last year, warned that the plan really takes meaningful freedom away from the states and has just a patina of flexibility. It's like the example I gave, your money or your life, but you can pay.
But you can pay it however you can choose any vehicle as long as you choose a black one, that kind of thing.
Very much like
Ms. Wood, and to that, one, do you feel it's flexible? But then also, as a clean air practitioner, how would North Carolina or any other state be able to actually implement this rule?
The flexibility is exactly as Professor Tribe described it, is illusory. And the example I like to use in describing the flexibility is it's as if I came to you, the state of North Carolina, and I said, I want you to give me change for $1. You can do it any way you want. It can be 100 pennies. It can be 4 quarters. I don't care. You just do it North Carolina the way you want. Well, the problem is North Carolina only has 60 cents. And so there really isn't flexibility there.
So in other words, what's being got it. Now, to that point, I want to go into something very specific because I think there again, I know we've been debating law and the interpretation. I'm a nurse and I'm much more practical when it comes to these things. So what I would like to know is based on this 111D provision in building block number 4, which is relating to the increased energy efficiency, how would this be enforced? And I'll start with you, Professor Tribe, and then just go to each one.
I would rather defer if I could.
That's fine. That's fine, Ms. Wood.
She is more of an expert in the intricacies than I am.
That gets to the essence of the problem of this rule, which is that it goes beyond the source, as I've talked about today. There is no mechanism in the Clean Air Act for you to go and require people to reduce their electric consumption.
And basically what we're talking about here is we're not talking about the state now or penalizing the state in some way. We're talking about individuals. We're talking about individual households. We're talking about individuals who may or may not be complying with these regulations.
Exactly. So either you're going to hold the individuals directly responsible, which isn't permissible under the Clean Air Act, or you're somehow going to try to force the electric utility companies to make their customers do it.
Correct. Professor Rivas, would you like to comment on this?
Sure. As I indicated earlier, I mean, the product here, what's being regulated is electricity delivered in usable form to consumers.
To consumers.
Now, no one is arguing, I don't think EPA is arguing that consumers should use less electricity or, like, take the bus one day a week or work at home or anything like that.
That's not absolutely building block 4.
To the point.
That is an interpretation of building block 4, and we can disagree with that, but I don't think we'll resolve in the next 52 seconds. Also, we shouldn't lose sight of the fact that nothing is being imposed on any state here.
Okay, but there again, I'm just reclaiming my time. We've already determined it's not the state we're talking about. We're talking about the individuals are the users of this energy, the individuals. So how would this, my question is, how would you enforce this?
States in their plans can come up with reductions in any way they choose. They don't have to do anything in particular. They can have trading schemes. They can enter into compacts with other states and have multi-state schemes. They have a million different options on how they can do this. They don't have to do it this way.
But building block number 4 talks about the individual.
Building block 4 is, the building blocks are used to determine the state reduction requirements. They're not imposing any requirement on any state or on anyone else. They're just a way of determining how states, to what extent states can reduce their carbon dioxide emissions.
Thank you, and I yield back the remainder of my time.
Gentlelady yields back. This time I recognize the gentleman from Texas, Mr. Flores, for 5 minutes.
Thank you, Mr. Chairman, and I want to thank the panel for joining us today. This has been a fascinating discussion, particularly with respect to government overreach. Professor Tribe, the question of takings has come up in the course of this conversation today. Professor Rivas a few minutes ago indicated that it wasn't a problem, but you indicate that the rule's impact raises Fifth Amendment or takings concerns. Can you tell us what you mean by that? Can you expand?
What I mean, I think, is best illustrated by decisions that involve not only the takings and compensation clauses, but the due process clause. As the Supreme Court has held in a number of cases, including one where the EPA initially promised confidential treatment to pesticide makers and then pulled the rug out from under them, and another in which the United States government offered companies more favorable accounting treatment if they would bail out failing S&Ls and then reneged. In cases like that, the Supreme Court has found a doctrinal basis either in the contract clause or in the due process clause or in the takings clause for saying that even though you haven't wiped somebody off the map entirely, you've left them with some value, if you lead them to take a course of action and then pull the rug out from under them, fairness requires some kind of compensation. And in particular, the way the coal companies have been led on here is well known. This was something that was encouraged by the government, and in particular, when they were forced to invest billions of dollars in meeting the requirements under 112 with respect to the hazardous pollutants, they were pouring money down a hole, and they were not told, guess what, it's all gone, because the state that you live in has no choice other than to put you out of business.
Well, that sort of brings me back to my next question related to 111D. This seems to be on shaky legal ground already. It's already the subject of lawsuits that haven't been finalized yet. And so, Ms. Wood, what happens if the states start implementing the final rule only to have the court strike the rule down? And what do these states do? What have they already started signing the contracts? People started breaking grounds on investments or making capital commitments for investments. What happens next?
Yeah, there's two sets of, harm that can happen here. One is to the states and the other is to the power plants themselves. And when you're looking at the states, they're having to start now to prepare these plans. In the litigation that's pending, the state of Alabama, for example, submitted an affidavit that said that this was by far the most complex undertaking that the state of Alabama Environment Department had undertaken in 40 years. So it's a lot of capital being expended to come up with these plans. Most states are going to need to enact legislation and put in place regulations. So if at the end of that time period, this is all found to be unlawful, well, all of that effort will have been lost. But more importantly, to the extent legislation and regulations have been put in place, all of that's going to have to be reversed. And, that's also going to be time consuming. And then, as you said, power plants need to start planning now, and so they can enter into contracts and can have financial.
Right. And what goes unsaid here, but is obvious, is that the consumers and the taxpayers and the ratepayers all bear the cost of that. Continue on Section 111D. It's the basis for the Clean Power Plan that the EPA has come up with. But this provision, as I understand it, has seldom been used in the EPA's 44-year history. The Supreme Court also recently said it's skeptical when an agency claims to discover in a long extant statute an unheralded power to regulate a significant portion of the U.S. economy. And so, Ms. Wood, another question for you. Isn't it correct that in the 1990 amendments to the Clean Air Act, only one Section 111D regulation has been promulgated that still exists?
Yes, that is correct. As Professor Tribe has talked about, there was one version of Section 111D that was actually promulgated. It is the House version. It is what is shown right now in the United States Code. And it precludes regulation of source categories under 111D if they're already regulated under 112.
Well, that was sort of my next question, as these have always had very limited reach.
Oh, yes, very limited reach. It really was designed by Congress to be a catch-all for something that slipped through the cracks. These sources are not slipping through the cracks. They're being regulated under 112 and having to install maximum achievable control technology.
Right. So there's never been an expansive use of 111D like this that we're proposing. So, Professor Tribe, would you like to comment?
Well, I agree.
You've got 2 seconds.
It's only been used for 4 pollutants and 5 sources. They're very specialized and localized, like municipal waste landfills or sulfuric acid plants, which give off acid mist. And the idea that it's nothing new, just business as usual, is the most fantastic account I've heard.
Okay. Thank you very much. I yield back.
Gentleman yields back. This time recognize the gentleman from Mississippi, Mr. Harper, for 5 minutes.
Thank you, Mr. Chairman, and thanks to each of you for being here. You've been very informative, and it is a challenging issue to every one of our states, a very expensive issue and proposition that's here, and the discussion on the Constitution is certainly very intriguing. And yesterday I saw in the vault at National Archives the original handwritten letter that Thomas Jefferson wrote following the Louisiana Purchase, and congratulating Congress on this new acquisition, which had not been approved yet. And him being a strict constructionist, he was, obviously concerned about people calling it unconstitutional, and he said it was extra constitutional. So, it's amazing how we've progressed in 200 years and how we look at things. But Professor Tribe, EPA and proponents of its regulatory approach say Section 111D serves as a catch-all that provides regulatory authority to ensure there are no gaps in air pollutant regulations. And I know we touched on it, but what are your thoughts about this gap-filling argument?
Well, it's the job of Congress to fill gaps in the law, and it tried to fill little cracks, as Ms. Wood suggested, not in a huge gap, when it passed 111D, little things that just weren't covered because they were not among the 188 hazardous pollutants that are regulated, under 112 at the source. But the idea that when an agency is not satisfied with the coverage of a law, it can sort of squeeze the law so that the hole in the legal ozone layer is sort of closed up is just totally fantastic.
Well, Professor Tribe, following that line, have you identified any evidence that Congress intended to provide EPA powers to expand its own regulatory authority when EPA identifies the need to do so? And how would that be possible under the Constitution?
Well, I think it wouldn't be possible, and I have found no such evidence.
Okay, thank you. Ms. Wood, I think everybody agrees that EPA has the authority under certain circumstances to set standards that people comply with by installing certain equipment. For example, catalytic converters have been added to cars to meet environmental regulations. How is EPA's proposed 111D rule different than that?
Well, it's different in the ways that I've just discussed, which is it's going beyond the source of pollution, and the bulk of the reductions that EPA is claiming from this rule are not actually coming from the source. They're coming from other areas. This is the first time that in its history that EPA has ever tried to apply any part of 111 in this manner. Rather than being a standard of performance, in other words, saying how a source should perform and at what rate it should emit, it's really a standard of non-performance. Let's try to figure out ways where these plants don't have to run. It's completely backwards and upside down. Nothing has ever been done like this. And in fact, if you think about it, if you're looking for the best system of emission reduction, which is what EPA does, not running it or shutting it down would always be best. And yet that's never what they've found before.
Thank you very much. Thank you, Mr. Chairman. I yield back the balance of my time.
Jim yields back, and that concludes our questions. And I want to thank the three of you for taking time to be with us and discuss this very important issue with a lot of profound impacts down the road. So, Professor Tribe, thank you. Ms. Wood, Professor Rivez, thank you. We look forward to continuing to work with you on this issue and others. And with that, we'll release the first panel.
Thank you, Mr. Chairman.
Thank you so much. Thank you. And I'd like to call up the second panel now, who've been very patient. And on this panel, we're going to really zero in on the practical impacts at the state level and what their thoughts are about this proposed rule. And we have four witnesses. Mr. Craig Butler, Ms. Kelly Speaks-Backman, Mr. Art Graham, and Mr. Donald Vandervaart. So if you all would take your seats. And just like the first panel, I'll introduce each one of you right before you give your opening statement. I do think it's important that everybody understand that today is Mr. Art Graham's birthday. So he's one of these. He's a fun-loving guy, and that's why he's here today to celebrate his birthday. But our first witness is Mr. Craig Butler, who's the director of the Ohio Environmental Protection Agency. Mr. Butler, thank you for being with us, and you're recognized for 5 minutes for a statement. And at the end of that time, we'll have questions for you.
Good morning, Mr. Chairman, Chairman Whitfield, members of the committee. I do appreciate the opportunity to testify before the subcommittee. My name is Craig Butler. I'm director of the Ohio Environmental Protection Agency, and I've been asked to provide testimony on Ohio's comments and interpretation of the Clean Power Plan. As reflected in our detailed comments and extensive comments to U.S. EPA, the proposal seeks to overhaul the nation's power generation, transmission, distribution systems by reducing coal-based electricity and instituting federally mandated reliance on energy efficiency, renewable energy under the guise of global climate protection. It is no secret, as we've heard today, that many states, including Ohio, that the Clean Power Plan is encumbered with significant legal problems and should not go forward. While I'm not here and won't discuss those concerns in detail, be assured that Ohio will continue to pursue these challenges either independently or joining with other states to prevent the likely illegal rulemaking from moving ahead. U.S. EPA's request for comment on more than over 500 different aspects of the proposed rule as it was published in the Federal Register, combined with the inability to answer basic questions throughout that comment period, clearly highlights that the plan has not been well designed and was rushed out the door to meet a predetermined schedule. Nonetheless, Ohio felt a strong obligation to dissect the proposed rule from a very technical standpoint. We took it very seriously. We partnered with our Public Utilities Commission of Ohio and conducted an extensive outreach effort to interested parties during the comment preparation. Our detailed review produced more than 180 pages of technical comments. One major flaw is how U.S. EPA inexplicably ignores efficiency improvements already made to our coal-fired power plants and instead orders sweeping new changes or improvements regardless of feasibility. For example, U.S. EPA plan requires an achievement of 4% or 6% efficiency improvement at all coal plants. We know this was established without any site-specific assessment in Ohio. In reality, Ohio's coal fleet will have recognized a 5.4% heat rate improvement between 1997 and 2016, and as a result of additional reductions may be very costly or if not impossible. In fact, carbon emissions will be reduced by 47% between 2005 and early 2016 from our power plants. Yet U.S. EPA's allocates no credit in the Clean Power Plan for pre-2012, quote-unquote, early adopters of energy efficiency improvements, increasing costs to achieve new state regulatory targets and threatening more closures of coal plants in Ohio. Ironically, after coal-fired units are required to make new costly upgrades, their ability to recover the costs in the marketplace is minimized by utilization restrictions as a result of the remaining EPA building blocks requiring natural gas plants to achieve a 70% utilization rate. It is nonsensical to force costly upgrades on one hand and only deny these same units the ability to run and pay for them. In another example, we believe U.S. EPA has misapplied the economic feasibility analysis to predict the reliability on the bulk power system. It's not clear if U.S. EPA may have consulted with the Department of Energy, North American Electric Reliability Corporation, Federal Energy Regulatory Commission, or power providers to identify and use well-known technical modeling software to specifically design to analyze how changes in the transmission will be affected. However, these organizations currently responsible for maintaining the grid and stability and reliability have warned of outages and voltage collapse if the plan is implemented as proposed. To Ohio, this signals that U.S. EPA failed to consult these organizations in a meaningful way while formulating this plan and does not fully understand the implications of the plan. As Ohioans discuss this issue across the state, we hear one overriding concern. Maintain our affordable, reliable power is critical to both the pocketbooks of Ohioans and continued economic development within our state. Ohio has been a manufacturing hub in the heart of this country since the Industrial Revolution. Fueled by electricity, which remains 9% below the national average, Ohio is home to a broad range of energy-intensive industries and is competitive on the national and global market. Clean Power Plan, with all its legal and technical flaws, presents a direct threat to these benefits to the Ohio consumer. One stunning statistic I will share with you is the Public Utilities Commission conducted a detailed analysis of the Clean Power Plan and indicates 39% higher electricity rates in calendar year 25 that will cost Ohioans $2.5 billion. In the last 4 years, Governor Kasich has supported an energy policy that is inclusive of all sources and generation. From our World-Class Energy Summit in 2011, where we discussed developing a broad portfolio of cost-effective sources, to recent legislative activity to include combined heat and cogeneration in our qualifying energy sources, we have and will continue to embrace the often overused but certainly relevant all of the above strategy. We do it because it's important to affordable, reliable energy and to protect the environment. I'll close by saying Ohio is willing and is very prepared to participate in a full national debate on carbon, the need or not, frankly, to regulate carbon emissions from power plants, and how Ohio is and remains committed to being a good steward of the environment. However, the Clean Power Plan is a seriously flawed proposal and should not be used to set unprecedented national policy. U.S. EPA should reconsider this misguided approach. Thank you.
Thank you, Mr. Butler. And our next witness is Ms. Kelly Speaks Bachman, who's the Commissioner at the Maryland Public Service Commission and chair of the Regional Greenhouse Gas Initiative. Thank you for being with us, and you're recognized for 5 minutes.
Mr. Chair and members of the committee, thank you very much for inviting me.
Your microphone is on, and move it up closer, please.
Thanks. I think it's with this chair. Thank you very much for inviting me to testify this morning. I'm grateful for this opportunity to comment on the proposal's costs, feasibility, and impact on consumers and electric reliability. As an economic regulator, first and foremost, my primary objective is to ensure that the environmental goals of my state are realized in the most cost-effective way possible while maintaining grid reliability. To this end, I'm pleased that the EPA has allowed states to work within the current construct of our electric grid markets by encouraging a regional approach to compliance. As one of the 9 states participating in RGGI, the experience of my state, as well as recent analysis completed by several independent grid operators, indicates that a regional path to compliance is the most efficient and cost-effective path forward. Together, our 9 states continue to successfully implement the nation's first fully operational carbon market. The RGGI program caps emissions by first determining a regional budget of carbon dioxide allowances, then distributing a majority of the CO2 allowances through regional auctions so that states may capture the allowance value for reinvestment into strategic energy programs. Our 9 states represent 16% of the U.S. economy and generate a total gross domestic product of $2.4 trillion U.S. dollars. The states work together within the current electricity markets to create a unified system for auctioning and trading carbon allowances so that our environmental goals are achieved through a least-cost, market-based solution. Although we've collaborated effectively for the better part of a decade, the RGGI region remains diverse in many aspects. We comprise 3 separate regional transmission organizations. We have different political landscapes and dissimilar generation profiles. For example, in Maryland, our generation remains predominantly coal. As part of RGGI and coupled with other state energy initiatives, however, we've been able to diversify our fuel mix and reduce our carbon footprint. Since 2005, in-state generation from renewables, nuclear, and natural gas as a percentage of total generation mix has increased from 36% to 55%, while in-state generation from coal has decreased 56% to 44%. Over our entire RGGI region, the power sector carbon pollution has decreased by 40%, while our regional economy has grown by 8%. That's from 2005 to 2013. Non-hydro renewable generation has increased by 47%, while our regional dependency on coal and oil has decreased. Our carbon intensity of the power sector has decreased at twice the rate of the rest of the country. So we believe that market forces, state policies, and programs such as RGGI are driving these cost-effective pollution reductions while simultaneously supporting our local economies. Our energy efficiency, demand response, and renewable initiatives, as well as policies to encourage fuel switching and to less carbon-intensive fuels, all work in tandem to reduce pollution and establish long-term solutions for a reliable energy infrastructure. Many of the complementary state strategic energy initiatives are funded using proceeds from these RGGI allowance auctions, creating a virtuous cycle of benefits that also serves to minimize ratepayer impact. I could go through the rest of my written statement, but I would very much prefer to just leave you with 5 points that we've learned as part of RGGI, and I'd be happy to take questions afterwards. The 5 lessons that we've learned and what we hope will be helpful to other states as they're crafting their plans, either state or regional, include the formation of one of the lessons stems from the formation of our intra and interstate agency relationships as part of the regional cooperative effort. These relationships and resources have spilled over into other initiatives such as distributed generation, electric vehicles, and compliance with other EPA and state environmental regulations. 2 is the pooling of staff resources and budgets. Basically, we can do a lot more with a lot less. We've been able to complete the necessary regional electric sector modeling in a timely fashion with built-in peer review. The 3rd is a regional mechanism stimulates active and productive stakeholder engagement. The 4th, regional consistency does not require the states to implement identical programs. We in Maryland have one way of using these proceeds. Those in New York, those in Massachusetts, those in the other states participating in RGGI base their investments on their own state policies and priorities. And fifth, lastly, and the most important lesson that we've learned by the RGGI states as it applies to the Clean Power Plan is that participation in a regional compliance effort will likely provide other states with the most flexibility moving forward. Initial hurdles surrounding the structure of the mechanism are not in fact insurmountable, as demonstrated by us in the RGGI states. Using this regional construct, the regional emission cap is the only enforceable mechanism included in the compliance plan. States retain jurisdiction over their own energy efficiency and renewable energy programs and can continue to offer these initiatives as complementary measures that help mitigate the cost of compliance for their ratepayers. Thank you very much for your time this morning.
Thank you. Our next witness is Mr. Art Graham, who's chairman of the Florida Public Service Commission. Mr. Graham, thanks for being with us, and you're recognized for 5 minutes. And happy birthday, as I said earlier.
Thank you, Mr. Chairman. Thank you for the birthday wishes, and thank you and Subcommittee for allowing me the opportunity to come speak today. My testimony is my perspective as a utility regulator. I believe the EPA's Clean Power Plan, the CPP, threatens the affordability and reliability of Florida's electric power. Let me get straight to what I feel is the most troubling aspect of the CPP. That would be both the fairness and the cost. In Florida, we have below average CO2 emissions because of the following. We shifted a lot of our generation to low emission natural gas early on. We offered incentives to harvest the available heat rate improvements over the past 30 years, and through energy efficiency programs that have already reduced consumption by 9,330 gigawatt hours. Now, all these things allowed us to realize a 25% decrease in CO2 emissions from 2005 to 2012, but yet none of these things are recognized by the current plan. However, in the current plan, 34 states have higher CO2 emission rates than Florida, but only 15 states have higher reduction percentage required by the CPP. The second concern I want to express this morning is the cost of compliance. EPA's responsibility is economic protection, which is very important. I think it's very important. But my responsibility is protecting the consumer from excessive costs and the reliability of the power grid, which I think is equally as important. The costs of implementing the CPP aren't certain at this early stage, but the utility customers will certainly pay for EPA's dramatic shift away from economic planning and least cost operation. How much is not exactly known, but the cost analysis I'll talk to you about this morning is from our Florida Office of Public Counsel, and you'll get some idea from there. OPC's job is to represent the utility customers' interests. They took a very conservative approach and applied EPA's own cost assumptions. The specifics are in my written testimony that I submitted earlier. So briefly, under Building Block 1, applying the approximate midpoint of EPA's cost range to achieve approximately 6% improvement, Public Counsel identified a cost of $1.15 billion. Under Building Block 2, Public Counsel's conservative methodology precluded costs associated with this building block, but the issues were as following. Quantifying costs for the EPA's overstatement of gas plant capacity, the cost for required new gas transportation infrastructure, i.e. pipelines, the cost for replacing generating units into retirement long before the end of their useful life, i.e. the stranded costs. I can tell you these are all big-ticketed items. Under Building Block 3, using the U.S. Energy Information Agency's most recent cost for utility-scale solar, replacing 10% of the conventional capacity would cost Florida $16.8 billion. Under Building Block 4, for Florida, EPA's 10% reduction equals 5,745 megawatts of avoided capacity. Our demand-side program costs $1.48 million per megawatt of avoided capacity. So EPA's assumption will cost us over $8.5 billion. Now, Florida's Office of Public Counsel limited itself to costs that can be cleanly calculated applying EPA's numbers with the most basic government data. Counting only the most obvious and easily qualified costs, the expense to Florida ratepayers start at almost $27 billion. That works out to about $2,800 per utility customer. However, the complete cost is much, much higher. In short, if EPA wants to reduce the carbon emission by 30% from the 2005 levels, well, then let's use the 2005 levels as our baseline. It makes no sense that EPA won't recognize what states have done since 2005. It's unfair to punish early efforts with bigger and more expensive requirements. And I have some more, but I don't want to run over.
Okay, Mr. Graham, thank you very much, and we'll have an opportunity to ask questions as well, and then we have your full statement for the record. This time I'd like to introduce Donald Vandervaart, who is the Secretary for North Carolina Department of Environment and Natural Resources. Thanks very much for being with us, and you're recognized for 5 minutes.
Thank you. Chairman Whitfield, Ranking Member Rush, and members of the subcommittee, thank you for inviting me to testify this afternoon. I have the privilege of serving Governor McCrory as Secretary of the Department of Environment and Natural Resources, and I'm grateful for the opportunity to share my views on this very important topic. I'd also like to recognize Representatives Hudson and Elmer's, two distinguished North Carolina members who sit on this committee. The Clean Air Act specifically provides that states, not the EPA, have the primary responsibility for implementing programs that protect the air resources of this nation. It is an indisputable fact that states like North Carolina have been very successful over the past 30 years implementing programs that protect public health and welfare while providing for economic development. Before I comment on the specific issues of state resources, I would like to note that issues that are omitted from my comments. First, my comments will not address the scientific uncertainty of the impact of human activity and greenhouse gases have on climate. My comments do not discuss the accuracy or the lack thereof of the IPCC models relied upon by the EPA to develop this rule, or the divergence between the model's predictions and actual temperatures over the past 15 years. Although these issues are critical in any decision to regulate greenhouse gases, my comments are limited to separate but equally important aspects of any final 111D rulemaking process, that is, state resources, state and utility planning efforts, and the legal frailty of the proposed rule. I will address the state resources and advocate for what North Carolina calls the legal trigger approach to Section 111D implementation. Given the certain litigation that will ensue if the proposed rule under 111D is promulgated, states such as North Carolina are at risk of investing unnecessary time and resources developing and enacting state 111D plans prior to the resolution of litigation. North Carolina recommends that the EPA amend the rule's submittal deadlines to require states to submit a 111D plan only after the conclusion of a judicial review process. Traditionally, when the EPA promulgates a new rule that sets forth requirements designed to address some aspect of the Clean Air Act, each state must take action, usually in the form of legislation and rulemaking, to avoid sanctions directly or avoid sanctions on its sources. The state then submits a demonstration to the EPA for approval, which can take anywhere from a few months to many years, during which time the states implement their rules. If the rule is struck down, however, the state is forced to uproot its earlier work and begin a new planning process, legislation, rulemaking, implementation, and enforcement. And the process must often be amended again when EPA revises its illegal rule in an attempt to satisfy the courts. This is not just an academic concern. There are several recent cases where this study in futility has occurred. The EPA's attempts to address economic inequity in regional energy markets through interstate pollution rules such as the NOx-SIPCAL, the Clean Air Interstate Rule, and the Cross-State Air Pollution Control Rule are prime examples. There is universal agreement that the 111D rule will fundamentally restructure how energy is generated and consumed in America. I would argue that EPA's Section 111D rule is to energy what the Affordable Care Act is to health care. This fundamental change to America's electricity model will come at the hands of a rule that few consider legally firm. The EPA acknowledges in the rule that it is structured to survive even if portions of the rule are struck down. In my more than 20 years of implementing air quality rules, I am not aware of any rule where the EPA has made an a priori acknowledgement of legal infirmity. Despite the rule's uncertain future, state plans would need to move forward to allow, for example, switching from a cost-based energy dispatch model to a carbon dioxide dispatch model. Under the EPA's current proposal, legislative changes, utility resource planning, and regulatory execution must proceed, while 111D is under judicial review. EPA's acknowledgement of the legal frailty of their creative interpretation of the Clean Air Act not only argues for the legal trigger, but it also calls Chevron deference into question. In this rule, like many other EPA rulemakings, the EPA characterizes statutory language as unambiguous to invoke Chevron deference. Unfortunately, the EPA's legal track record is so poor that one can only wonder if Chevron deference should be withdrawn because the agency has abused its public trust. Simply stated, if the EPA wants to upend the world's greatest power system by forcing a round peg into the square hole that is Section 111D, it should have the prudence to allow the final rule to be reviewed by the courts before requiring states to undertake such a profound effort. Thank you for the opportunity to testify.
Thank you, Mr. Vandervaart, and thank all of you for taking time to give us your views on this important issue. I'll recognize myself for 5 minutes of questions. In my opening statement, I described this proposed regulation as being characterized as extreme, a power grab, radical, unprecedented, and even unlawful. And we get I think you can come to the logical conclusion that this is being implemented to implement the President's international agreements. And I would ask each of you, the EPA has given the states 13 months to come up with a state implementation plan if this regulation is adopted. Is that an unusually short period of time from your personal experience with EPA? Mr. Butler.
Mr. Chairman, it's a very short time frame, frankly, one which that we don't believe we could ever meet.
Okay.
And I know some states are different.
Okay, so it's very short. You don't think you could meet it. What about you, Ms. Speaks-Bachman?
Well, thank you for the question. I would say that for my state and for the other 8 participating RGGI states, since EPA has explicitly allowed our construct to exist, we already are practicing what they're asking for us.
So you're saying you could meet the
Absolutely.
proposed regulation. Mr. Graham?
I agree it's short, and I don't think we can do it either. We'd have to have several special sessions.
What about you, Mr. Vandervaart?
The plan that we anticipate submitting, we could meet. It's not the plan the EPA is seeking.
Okay. Now, why this has been described as a real takeover of the electric system in America, generating system. Why would EPA, from your personal view, would they want a 13-month time period to allow states to implement something this complicated? What would be the reason for that? Mr. Butler, do you have any idea?
Mr. Chairman, I think it's, as I had pointed out in mine and you had in your testimony, I think the President has a goal that he is trying to meet and is asking the states to help them meet that goal with a very short time frame.
Okay. Why do you think, Ms. Speaks-Bachman?
I can't say exactly why, because I don't agree with the premise necessarily that it is a takeover.
Okay. What about you, Mr. Graham? Do you have any idea why?
Mr. Chairman, I would agree with you and Mr. Butler on that.
Okay. Mr. Vandervaart?
I believe that this fictitious sense of urgency is not about emission reductions. We are meeting emission reductions thanks in large part to the free market and the low cost of natural gas. I believe the urgency has to do with the fact that they have sensed that the veil of legal authority has been stripped from this rule and it will soon meet its demise. They want to force regular utility companies to begin their planning process, which is a lot longer than 13 months, so that they can get this ball rolling.
And, you know, in our first panel, you listened to the constitutional arguments and so forth. How many of you actually believe that the average citizen out there has any basic understanding of the impact of this regulation, what it would be? Do you think the average citizen even has any input or insight into this, Mr. Butler?
Mr. Chairman, we did an extensive outreach and as we prepared our comments, and we took a lot of public comment on this. But irrespective of that, I think in general, the public does not understand any of the technical details or any of the legal construct here that is under debate, nor, frankly, what the potential cost might be, because we have not, frankly, been able to understand the plan well enough or know what
you probably don't understand what the cost implications are.
Right.
Do you think the average citizen understands the potential impact of this?
I believe that public sentiment is increasingly aware of climate change and the issues.
I'm not talking about climate change. I'm asking you,
And
do they understand the impact, in your opinion, of the consequences of this?
The impact in our RGGI states is less than 1% for the overall.
So you think they do understand?
So
Okay,
that impact is not necessary.
Mr. Graham, what about you? Do you think they understand?
I don't think they have any idea. We've reached out quite a bit and got very little feedback. I think the power generators have an idea of what this is going to cost, but I think the financial impact, and we really haven't put out what we proposed that some of the numbers are until we get the final plan coming back.
You think they understand, Mr. Vander Vaart?
No, sir.
Okay. Now, Mr. Graham, you talked about, you viewed this as unfair and very costly. Is that your honest opinion of the impact of this regulation on the state of Florida?
Oh, without a doubt. You know, what gets me, and you see in all the EPA's data, that they said they want to decrease 30% of the CO2 emissions from the 2005 numbers. Now, one of the things that Florida's already done from 2005 to 2012, we've already jumped ahead of a lot of this stuff. We switched a lot of things over to natural gas. We're right now about 65% natural gas. We've done a lot of other improvements since then. And for you not to take into account, because they're using 2012 as a baseline. Now, the problem you run into there is that was an all-time low for natural gas, so we are using so much more natural gas, so the carbon emission that they're putting out there is so much lower than it was, like I said, back in 2005. And so I think it's unfair that we're not getting that credit.
Thank you. My time has expired. At this time, I recognize the gentlelady from Florida, Ms. Castor, for 5 minutes.
Thank you, Mr. Chairman. Thank you to the panel. Mr. Graham, it recently came to light that Florida Governor Rick Scott has an unwritten policy that bans the use of the terms climate change and global warming. A number of state employees and scientists from the Florida Department of Environmental Protection, the Department of Health, the Water Management Districts, the Florida Department of Transportation have all come forward and said this is the case. I've read your testimony. Nowhere in your testimony does it use the term climate change or global warming. Is that a product of Governor Scott's unwritten policy?
Absolutely not. I was told to come here and talk about what the financial impact is going to be of implementing 111D. And so that's why that was in my written testimony.
Well, and I find your testimony very curious because the Florida Public Service Commission has not been on the side of consumers. And they have not, your words, you say the Clean Power Plan threatens affordability for consumers, and the Commission will protect consumers from excessive costs. But let me give you a few examples of the costs that Florida's heaped on our customers. The PSC recently gutted energy efficiency initiatives, even though efficiency can meet demand at a much lower cost, at a fraction of the cost of building new power plants, and can help customers reduce energy use, put money back into their pocket, create jobs at the same time. I mean, we would see larger savings on bills, but that's not the business model in Florida. So those stunning rollbacks in energy efficiency, especially at a time when we've got to be looking for ways to save on carbon pollution and save money. Here's another example. The Public Service Commission has really worked over the past few years to stifle renewable energy in Florida, and especially solar. You recently stated at a Public Service Commission hearing that Florida Sunshine State branding is nothing more than a license plate slogan. Well, I hope everyone was watching the weather over this past winter. Florida is the Sunshine State. We rely on tourism. You cited a National Renewable Energy Lab report, but in fact that report from July 2012 said Florida is indeed ranked third in the nation for total estimated technical potential for rooftop solar voltaics in the U.S. That same report said Florida clearly has the best solar resource east of the Mississippi River, but the Commission has scrapped solar rebates also going to cost us money, especially with the new requirements of the Clean Power Plan. And then the best example is what the Public Service Commission and the legislature has done to increase bills, especially if you're a Duke Energy customer. And my colleagues might not be aware, but Florida had adopted an advance recovery fee that allowed the utilities to collect costs in advance for building power plants. And in fact, even when Duke Energy had to scrap a power plant and had to put another one on mothballs, without creating 1 kilowatt hour of energy, customers in my neck of the woods in Central Florida are on the hook for $3 billion, and that's modest, in costs. $3 billion, not one kilowatt in energy. So when I hear you talk about affordability and that you're really concerned about the consumers, the record simply does not support that in the state of Florida. I want to give you time to respond, but we have an obligation. We have a shared obligation to confront these issues. And I'm sorry, I'm going to give you a little time to recover, but think about the state of Florida, what consumers are going to have to pay in stormwater damage, cost to renourish beaches. What if we have a more powerful storm? That comes out of property taxes. You're looking at it in a very constrained way, a utility-concentric way, and that's not reality in our state. Go ahead.
Thank you. We cut back a lot on the energy efficiency programs because we've done so much so far. As you heard me say earlier, since we started this program, we've achieved 9,330 gigabytes worth of energy.
Mr. Graham, that's simply not the case. There's report after report after report that says the state of Florida is so far behind. Now we're down to about 0 in our energy efficiency goals because the business model is backwards. It is not a model that helps address the modern challenges. It's all about how much energy you can sell, and utilities now need to be compensated for helping consumers save money. And I'd really recommend that you take this obligation seriously and think about the cost to consumers from here on out. Thank you.
Ms. Castor's time has expired. At this time, I recognize the gentleman from Texas, Mr. Barton, for 5 minutes.
Well, thank you, Mr. Chairman. I had meetings in my office, so I've been listening to the hearing on the television in my office, and I want to commend all 4 of our panelists. I thought your testimony was excellent. I'm going to start off with a basic question for each one of you. We'll start with you, Mr. Butler. Are the requirements in this clean power plant necessary for Ohio to meet any pending non-attainment areas in your state?
No, sir.
Okay, Ms. Bachman from Maryland.
Speaks Bachman, yes, sir. The programs that we already have in place in Maryland have us in good stead to meet the goals of the Clean Power.
So it's not necessary in Maryland. Okay. Gentleman from
No, sir,
North Carolina.
It's not necessary.
And from Florida.
Florida,
North Carolina. I've got you backwards.
But same answer, no.
So this is not a necessary thing under the Clean Air Act amendments to meet any standards for non-attainment. In fact, is it a true statement that nothing in this Clean Power Initiative sets a standard of emission reduction in your state? Is that a true statement? There's not a target you have to meet in terms of parts per million or anything like that.
It is not, sir.
It is not. Is it a true statement that what this is social planning imposed on your state by the federal government? We'll start with you, Mr. Butler.
We believe it's an unprecedented action that, frankly, does not have any congressional intent behind it.
Now, Mrs. Speaks, Bachman, I was impressed with what you said in your testimony. It sounds like Maryland is part of a regional group that has voluntarily come together, set your own goals, and increased your renewable energy portfolio and done quite a bit of good things. But you did that because the compact or the coalition that your state's a part of made a voluntary decision to do that. Is that not correct?
Yes, sir. We voluntarily decided to take control of our environment, of the reliability issues that we were facing, and with cost increases to our ratepayers.
And I've got no problem with that. I think that's good. I'm glad Maryland's doing it. But how would you feel if we passed a law here that said Maryland had to use triple the amount of Texas-produced natural gas in that? Would you like that? Clean burning Texas natural gas, I might add.
Well, seeing, sir, is that we use plenty of Pennsylvania clean natural gas.
Yeah, but I understand, and I'm not here to knock Pennsylvania. But my point is,
but sir, I think the issue, I think the question that you're asking me is about being forced to use one particular type of fuel or another, which is not necessarily how this Clean Power Plan is structured. This Clean Power Plan is structured.
Well, in the case of Texas, Texas has to, if Texas decides to try to comply with this, we have to shut down 45% of our existing coal-fired power plants, 2 of which are in my old congressional district. Those 2 power plants are the economic linchpins in their counties. These are rural counties in south central Texas. One power plant's been there over 40 years. The other power plant's been there 25 years. I mean, they are the economic mainstay in those particular counties, and they'd be shut down. They'd be shut down for no environmental reason, no environmental positivism, none. As the gentleman from West Virginia or Virginia pointed out, 0.6% decrease in CO2 over a 30 or 40-year period. I mean, it's crazy. The chairman asked a question about why the 13-month period to comply, and y'all were very polite about giving non-answer answers. But I think the reason is because the Obama administration is going to be out of office, and they want this thing put in while they're still in office. Now, that's speculation on my point, but it's informed speculation. Again, I got no problem with what any of your states are doing, and I'm extremely impressed with what Maryland is doing. I think that is a good thing. I believe in states' rights. New York doesn't want to allow hydraulic fracturing, so they don't. Pennsylvania allows it, but with different reporting requirements than Texas. I believe in federalism. It's a good thing, but I don't believe in this new Clean Power Plan initiative that is imposing a social policy on the states with no environmental benefit and no real opt-out provision. With that, Mr. Chairman, I yield back.
Gentleman yields back. This time recognize the gentleman from New Jersey, Mr. Pallone, for 5 minutes.
Thank you, Mr. Chairman. Commissioner Speaks-Bachmann, I wanted to ask you a question about the Regional Greenhouse Gas Initiative.
Anytime, sir.
I wasn't here for your testimony. I had to go to another committee hearing. But in your testimony, you state that through 2013, RGGI states reinvested over $950 million of auction proceeds in energy efficiency, clean and renewable energy, and other strategic energy programs. And you note that these proceeds have helped low-income families pay their energy bills, supported energy efficiency upgrades, and helped families and businesses install solar, wind, and geothermal systems at their properties. In fact, under RGGI, just last week, the sale of 15.3 million carbon dioxide allowances netted $82 million and set a record high price. So the question is, the RGGI program seems to be the most effective and efficient way for states to meet the standards set forth in the EPA's Clean Power Plan. Can you tell me about the environmental and economic benefits this is providing to the state of Maryland?
Yes, sir. Thank you for the question. And yes, in fact, we auctioned, there were an additional $82 million just last Friday announced in our just last previous auction. In Maryland specifically, we have reinvested the auction proceeds in consumer benefit programs that's helped more than 215,800 low-income Maryland families to pay their energy bills. It's supported energy efficiency upgrades at 11,800 low to moderate income households. helped 5,206 families and 201 businesses in Maryland to install solar, wind, and geothermal systems.
So, I mean, obviously the program has been tremendously effective in Maryland and other participating states, and these states are going to have a leg up when it comes to meeting the EPA standards. Now, I'm just mentioning this in part because that's why I'm so disappointed that in my home state of New Jersey, our Governor, Chris Christie, has withdrawn our state from the program, as you know. And not only is this going to hinder New Jersey's ability to meet the EPA standards, it's actually costing the state money. According to an analysis by Environment Northeast, since New Jersey withdrew from the RGGI program in 2011, the state has passed up more than $114 million in potential revenue, and the state could miss out on an additional $387.1 million through 2020. And those figures don't even account for the record price for allowances hit at the RGGI auction last week, which you mentioned. That's money that could be used to support energy efficiency upgrades and job creation like it's doing in Maryland and other participating states. So I know he's not with us here today, but I've called on Governor Christie to reconsider his decision to withdraw from RGGI because I think New Jerseyans deserve to reap the benefits of this successful, economically efficient program, which is reducing carbon emissions and creating jobs in the Northeast. And I have about a minute and a half. I know that if you wanted to respond to some of the questions that were asked before that maybe you didn't have time for, you could use the time to do that unrelated to my question.
Thank you very much, sir. May I just add that the car analogy in the panel before was so interesting to me, in that what can be done in for the car as a catalytic converter. But to me, when I think about a mass-based regional program such as RGGI and taking that same analysis, it's like having a catalytic converter, but then you put a variable toll on the roads. That's outside the box, right? It's outside the car system. And putting a toll on those roads, you can take the money and you can reinvest that in R&D so that you can further improve the equipment that's put on the car to reduce emissions. But in addition, you can take those revenues and further control traffic by putting the tolls on certain roads that are busy. You can do things like improving those roads themselves. There are ways to reinvest and to make this a positive. I don't think it's mutually exclusive to help your environmental goals and to build your economies.
All right. Thank you so much. Thank you, Mr. Chairman.
Thank you very much. And before I recognize myself for 5 minutes, I'd like to ask unanimous consent from the committee to enter a letter dated December the 1st, 2014, from Director Butler of the Ohio EPA to the respond and also the executive summary. And these documents were submitted to the U.S. EPA as part of their comments to the proposed Clean Power Plan. Without objection, so ruled. If I could start, Director Butler, and also to all of our panel, thanks very much for being here. Again, it's been very informative. But, Director, if you would you expand on the reference you made to the differences in the 2005 and 2012 baselines and how this would affect Ohio by not taking into consideration the early action that many have taken to improve that efficiency?
Mr. Chairman, thanks for the question, and I think Mr. Graham made a couple of very relevant points in his testimony to this fact as well. Ohio has many utilities that are very early adopters in making sure that their plants run as efficiently as possible. Frankly, the hundreds of millions of dollars that they've invested will be left on the cutting room floor, if you will, if the Clean Power Plan, which talks about a 2005 implementation date, is passed. In reality, that date of looking to develop a plan is all based on the year 2012. So any emission reductions or, frankly, efficiency improvements that have been made prior to 2012 will not count. We think that not only disincentivizes our utilities from doing that work, but it, frankly, also makes it much more difficult for them to comply, if not exceptionally more expensive for them to comply going forward with meeting the new Bucket 1 requirements of having a 4 to 6% energy efficiency improvement. Further, we've talked to our utilities as part of our dialogue and comments on the Clean Power Plan. They think it's fundamentally very difficult, if not impossible, to reach that 4 or 6% efficiency improvements at our existing utilities. Our fleet has gotten much more efficient, ironically because of many of those units were shut down because of the mercury standard. Others were improved because of they wanted to be more efficient and generate more power into the grid. But those costs were heavy, and they think that a 1 to 2% improvement would be all that they could develop and to comply with a Clean Power Plan.
Thank you. If I could continue, Director, could you also explain the issues you foresee with the cost and the efficiency related to the EPA's building block number 2, which will result in the natural gas-fired units used for base load power and coal-fired plants into peaking power?
Mr. Chairman, I think the earlier reference about fundamentally the Clean Power Plan fundamentally is changing the electric distribution market from really one that is based on cost to one based on environmental impact, and that's a serious problem. In addition, just the discontinuity between the way EPA has set up the Clean Power Plan versus Bucket 1 on efficiencies at power plants versus Bucket 2, where they're wanting to see natural gas generation run at a 70% rate. I think we see two fundamental problems. One is we will see significant closures, and as we already have, of our coal-fired fleet. And we will see some, but I don't know yet how much natural gas generation come online. There's a disconnect in how those work. So we're really concerned, as many others are, about the power grid being able to supply power. Fundamentally, we also find an inconsistency here. While EPA is requiring or suggesting that the power plants become more efficient, invest hundreds of millions of dollars to do that they not be allowed to run to recover those costs because they're then driving gas to take over that capacity.
Well, when we look at Ohio, right now, is Ohio about 71% coal-fired?
Yes, sir.
And when you look down the road at what the EPA is ordering, and it was already discussed, I think, by the chairman, the question really comes into, with all these costs being put on these power plants, who's going to pay for that in the long run?
Right. Mr. Chairman, we're very concerned because we think all of those costs get passed on to the consumers of Ohio.
And also, when you've been, especially when you put out your discussions with the EPA, have they ever talked about, what the consequences are? Did they look at what it would do to a state like Ohio that's 71% coal generated, especially for our business communities and the people that work in those factories and businesses?
Mr. Chairman, I believe they probably do think about Ohio, although we were very concerned, frankly dismayed, when U.S. EPA, they do talk about they've had some extensive outreach across the country, and they did 10 listening sessions across the country. We frankly invited, as did our states in West Virginia and Kentucky, to come to any three of our states and hold a listening session to see and hear from the general population that we're actually going to be very much impacted by this Clean Power Plan. And they elected not to come to any of our three states.
So you put on a invitation, and they just did not come?
Yes, sir.
Thank you very much. My time has expired, and the chair will now recognize the gentlelady from California, Ms. Capps, for 5 minutes.
Thank you, Mr. Chairman, for holding this hearing, and I want to thank all of our witnesses for your testimony. It's so clear that the power sector is responsible for a major portion of carbon dioxide emissions in the United States, but it's also clear that these emissions are causing our planet's climate to change at an unprecedented rate. We need to act today to curb these emissions and prepare for the consequences that are forecast. Fortunately, and Ms. Kelly Speaks-Bachman, you spoke to this, that the Regional Greenhouse Gas Initiative, or RGGI, has really impressively reduced emission rates and has done so while also improving the regional economy and fostering job creation. My colleague from New Jersey asked you about that, and unfortunately, apparently his state of New Jersey is backed away from it, but I hope that this momentum will build. I think it's clearly possible to increase energy efficiency, reduce emissions, and provide affordable energy for local residents. So in addition to carbon emissions, the power sector generates so many other harmful pollutants, including sulfur dioxide, nitrous oxide, and mercury, to name a few. In addition to exacerbating the impacts of climate change, these pollutants have direct impacts on human health, leading to increased rates of respiratory problems, contributing to heart attacks, strokes, and even premature death. This has been documented and is being documented. The benefits of reducing carbon dioxide and these other pollutants under the Clean Power Plan will likely have benefits that far outweigh the cost of implementation, especially in the health sector. And I wanted to ask you how this implementation of RGGI has affected the benefit of human health in your area.
Thank you for the question. As you know, we have, in Maryland especially, we are a little bit downwind of some of the coal plants that are in the Midwest, and they have directly affected the health and the costs of that health to our citizens. And so as part of the effort that our state has undergone to try to mitigate those health issues, as well as to mitigate the reliability issues that we have had from frequent storms, increasing frequency and severity of storms, the costs that we have had, our ratepayers have had to incur in order to build up resilience against such storms. There are a lot of costs aside from the work that's going to be done but under the Clean Power Plan that need to be taken into account when you're doing a full cost benefit scenario.
Thank you. Significant reductions in sulfur dioxide and nitrous oxide and mercury has benefited over the long haul, but they are offset by downwind and other aspects that tell us that we're not fully where we want to be yet. Mr. Butler, I wanted to turn to you if I could. In August of last year, the waters off Lake Erie, off the coast of Toledo, experienced a harmful algae bloom that impacted drinking water for about 400,000 people. Am I correct?
Yes, ma'am.
The science is increasingly clear that harmful algal blooms will become more severe and frequent in the future due to climate change. This means more human health costs, more taxpayer dollars spent on cleanup, unless we take action to reduce carbon emissions. In your testimony, you focused exclusively on the financial costs of implementing the Clean Power Plan, but in the constraints of time, perhaps you weren't able to reach any of the benefits. Would you agree that human health benefits, such as fewer harmful algal blooms and cleaner air, should all be considered in doing a full assessment of the Clean Power Plan?
Mr. Chairman, Ms. Capps, if you have an opportunity in our extensive comments we submitted to U.S. EPA and then were brought into the record today,
great,
you will see an extensive summarization of our issues related to this issue about suggesting that there will be significant human health improvements by regulating carbon.
Mm-hmm.
We do not believe that's the case and do not believe that the science proves it. Now, however, there are a lot of reductions that come along. We've improved our sulfur dioxide and ozone emissions in Ohio and in our downwind states. I mean, we do not deny the fact that there have been many, many, many improvements to public health, but I think it's not appropriate to tie that back to CO2 emissions.
Perhaps that needs to be. But perhaps we need to do more studies along that health. The EPA's proposal, I believe, the Clean Power Plan, is an important step forward in combating climate change, will ultimately lower. How this is impacted, as your colleague sitting next to you indicated, it takes some time, and I believe we should go further into studying the effects of changes that are being made more thoroughly as they relate to regional and other factors, this is all about the health of our constituents, and I know I'm out of time, so I support this plan, and I'm going to yield back now.
This time I recognize the gentleman from Virginia, Mr. Griffith, for 5 minutes.
Thank you, Mr. Chairman. The gentlelady just referenced in her comments about her concerns about global warming and the health concerns, and then she went on to say that maybe we need to take some more time, we need more studies on the health. Mr. Butler, it's my understanding that, in fact, the EPA has not done any science on this particular regulation and how much it would change climate change, but that using the normal EPA modeling procedures, the American Coalition for Clean Coal Electricity did run an analysis on how much the rule would reduce climate change, and the American Coalition for Clean Coal Electricity found that atmospheric CO2 concentrations would only be reduced by less than 1% in 2050. The increase in global average temperature would only be reduced by 16 1,000ths of a degree Fahrenheit in 2050. Sea level rise would only be reduced by 0.3 millimeters or 1/100th of an inch. This is the equivalent of a piece of paper or a couple of pieces of paper. And so taking that all into consideration, well, first let me say, do you know of any other studies out there other than the one that I've referenced that indicate there's going to be some huge change to what sometimes is referred to as global warming, but more commonly, particularly in the East, is referred to as climate change since warming hadn't happened?
Yeah, Mr. Griffith, I'm unaware of any additional studies. We did a very extensive search when we did our comments on the Clean Power Plan, and the ones that you referenced are many of the studies that we also took a look at as part of our review of the Clean Power Plan.
Okay, but you don't have any direct numbers from the EPA themselves.
We do not.
And notwithstanding the fact that they haven't taken the time that Ms. Capps referenced maybe to look at this matter and the health studies, et cetera, and whether or not this would affect anything, this rule is coming down your state's throat any day now, isn't it?
Yes, sir, it is. We're very concerned about the resources that it will take on our state levels to, on the one hand, have these discussions and perhaps even legal issues around the implementation, but at the same time go down the path of having to commit our state resources to develop an implementation plan that at the end of the day, one may not be necessary, two that may change significantly from where we started.
Right, and so your folks are being forced to go forward even though there's all kinds of legal implications going on. And as you could probably tell from the previous panel in the debate there, I am very well versed, and I believe the EPA does not have authority. We'll stay tuned and see what the courts say, but I don't think you can change the law just because you find some reference in the closet that says that maybe there was a different interpretation, because if either side adheres to their position, there is no bill. The Senate said it receded. Now, getting into all that legal argument, Secretary Vandervaart, your state's going to have to comply even though the legalities and the fight over the legalities may continue. You've got to go ahead and get a plan out there. Isn't that true?
Well, that's right. And I think that that's why I'm here. There are a lot of things we can say. I applaud Maryland and the rest for doing what they want to do. North Carolina has made major reductions since the 2005 date. America generally has dropped its carbon dioxide emissions from 2010 to 2013 by 10%, and it was all done without the benefit of a federal action. It was done primarily by the revolution that is our natural gas production here in America. But yes, the concern we have is developing legislation, developing rules. Our utility regulatory system has to be altered.
And you'll spend a lot of money going down that path, and then the Supreme Court comes out a year and a half, 2 years, 3 years from now, and all of a sudden it's all got to start over again. Chairman Graham, your power plants are facing that same problem, but even if this thing goes forward, a number of them are going to have to be shut down before their useful life ends. Isn't that correct?
That's correct. We're about 20% coal in Florida. Like I said, we've switched to a lot of natural gas early on, and they're talking about closing down about 90% of our coal plants.
And so you're going to be hurting, and also that means that you're going to have some stranded costs, and that means the increased costs will go on to your ratepayers. Isn't that correct?
It's almost like they paid for the plant twice. They paid for the plant, and they have all this useful life left, and they're going to have to shut it down.
And the beauty of natural gas and some of the energy revolution is that we can attract jobs back to the United States, but we have to have affordable energy. And this plan doesn't do much for the environment, and it damages our ability and our reputation in the world to have affordable energy. Isn't that true? I don't have time for an answer, but I assume that it is with most of you. Speaks Bachman, I agree you would disagree, but I recognize that and yield back.
Gentleman's time has expired. At this time, I recognize the gentleman from New York, Mr. Tonko, for 5 minutes.
Thank you, Mr. Chair. And thank you to our panelists for appearing before the subcommittee. The efforts, and Commissioner Speaks Bachman, let me address my comments first and foremost to you. Welcome and thank you for your service as chair of the RGGI Board of Directors. As you have noted, New York is a member of RGGI. In my last workstation before service here in the House, I was president and CEO of NYSERDA, the New York State Energy Research and Development Authority, which got me a seat at the RGGI table. And so very thankful for your leadership and for carrying forth with the mission of that plan. As a participant in RGGI, New York has been able to accomplish a great deal. Greater energy efficiency, cleaner air, expanded deployment of renewable energy technologies, and these are just a few of the benefits, many that are arising. EPA's proposal is just that at this stage, a proposal. I support its goals. As a proposal, I'm sure it will evolve and change perhaps before the final rule is released. There, however, seems to be a number of utilities and states that are claiming the goals of the proposal cannot be achieved without severe economic hardship and sacrificing our electricity reliability. You seem to take a different view. Why are you convinced that these predictions are wrong?
Well, thank you for your participation in RGGI as a state, and thank you for the question. I do take a different position, and in fact, I take the position that that RGGI, coupled with our other state policies, has helped us to improve reliability. So specific to the reliability issue, which is very near and dear to my heart, and it's actually part of my legal obligation as a commissioner of the Maryland Public Service Commission. We work within, we have implemented RGGI within the construct of existing markets, and that includes the North American Electric Reliability Corporation's oversight of bulk system reliability. It includes FERC's retaining its authority over the market's design. It includes also reliable dispatch of least cost resources remaining with our grid operation system. So this is not an upending of the systems. We have been doing this for 8 years, and we have had fewer reliability issues because we've been able to support programs such as demand response and energy efficiency to help reduce the load in specifically load pocket areas.
Thank you. And also, there are those who would argue that sound stewardship of our environment and economic recovery, the growth of our economy, cannot go hand in hand. Are there any stats that you can cite in terms of perhaps job growth in the energy areas that have enabled us to strengthen our economy and provide for cutting-edge new opportunities with innovation as it relates to the energy arena?
Yes, sir. I can speak specifically to the state of Maryland with respect to jobs. I'd have to look up that number, but we have. I believe it's in my written testimony, sir. But we have created jobs and we have improved our economy while we have reduced by 40% our carbon dioxide from power plants. And I'm sorry, I don't have that number at my fingertips.
Well, I'm certain that you also hear other participants at the RGGI table representing that array of states. But I think it can be documented that we've grown a new culture of job activity, all while strengthening the environmental outcome. And the sense of environmental justice that has been produced by RGGI accompanies that of social and economic justice. So, you know, I think that there's this whole silo effort to look at certain impacts needs to be looked at in a fuller array, a broad view that provides for a strong context of a better future for all of the states involved.
Absolutely, sir. And I just recalled the number. In the first 3 years of our program alone of RGGI, we've created 16,000 job years in our region.
How many?
16,000 job years in our region. Based on the further reductions that we made through a program review in 2014, an independent analysis by the analysis group has shown that we will add yet another 130,000 job years to our region.
Thank you very much. And with that, I see my time is up.
Gentleman's time
There,
has
I yield back.
expired. This time I recognize the gentlelady from North Carolina, Ms. Elmers, for 5 minutes.
Thank you, Mr. Chairman, and thank you to our panel, especially to you, Secretary Van der Vaart, for being here from North Carolina. As your Secretary, as your position as Secretary of DENR in North Carolina and as an attorney, can you reflect a little bit about the discussion that took place on Panel 1 about the ambiguities that exist between the rule, the 111 and the 112, especially focusing in on back to 1990 when it was first put forward?
Yes, ma'am. That's a good point. The previous discussion, I would warn you all, maybe appears to me the setting up of a straw man, the question of whether the codified versus the statute at large language actually controls. The fact of the matter is it doesn't matter. Even if you take the statute at large, there is no ambiguity. And the reason is in 1990, the Clean Air Act under Section 112 was fundamentally changed from a pollutant-based program to a source category-based program. And therefore, the language in the statute at large is entirely consistent with what happened at that point. And I'm afraid that the previous discussion, for one reason or another, may have missed that. And so it's very, very good that you keep that in mind. Thank you.
And then getting back to some of the discussion that took place in the first panel, one of my questions is really about, implementation of this, and especially when it comes to 111 in the building block number 4. And there again, Secretary, from your perspective, how can this possibly be enforced, or can you foresee a way that North Carolina or that the EPA would actually be able to enforce this on North Carolinians?
That's a very good question, and we've thought very hard about it. Another misunderstanding that many people have about the Clean Air Act is that somehow 108 and 110 are implemented similarly to 111. That's not the case. When a state fails for whatever reason to submit an approvable plan under 110, 108 to protect NACs, the state itself is subject to sanctions, including highway funds removal. That's not the case in 111. If we do not submit an approvable plan, there's no downside for North Carolina as such, as the government. However, the federal government will then enforce directly to the source. And so, Representative Elmers, you're giving me a specter of what happens to my grandma when she doesn't screw in a CFL bulb in her house. Is she going to be thrown in jail by the feds? Am I going to be thrown in jail because I'm somehow missing my obligation? Or is the utility executive somehow going to get thrown in jail when really maybe the EPA should be thrown in jail? So.
Well, there again, it's part of that ongoing discussion of, comparing apples to oranges and kind of alternative universes when we're talking about this issue. My final question for you, Secretary Van der Vaart, is there again, looking towards our North Carolinians, is it economically feasible and fiscally responsible for us to foresee a future where we go from a cost-based energy dispatch model to a carbon dioxide-based dispatch model?
We can put a man on the moon. We can certainly do this, but it'll be at a cost. And unfortunately, the people who are going to bear that cost are the ones least able to afford it. It's going to be our lower and middle-class folks. It's going to mean the job losses for high-paying manufacturing jobs because electricity prices is fundamental to siting of new manufacturing. So yes, we can do it. Is it legal? Absolutely not. And in fact, as you heard, it's already been going on in a more cost-effective manner by the states themselves. So what we have here is a federal government attempt to upend, as I said, the world's greatest electricity system through a little-known codicil in the Clean Air Act.
Thank you, sir. And I'll just close out by saying that, North Carolina has made such strides, and thank you. A lot of it is due to your leadership and, moving forward on clean energy. And I believe North Carolina and so many other states that have taken these steps already need and deserve that credit. So thank you all to the panel, and thank you, Mr. Chairman. I yield back the remainder of my time.
Lady yields back. This time recognize the gentleman from Ohio, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman. I appreciate it, and Director Butler, thank you for joining us today from the great state of Ohio. A lot of concerns there about the things that we've talked about this morning. Director Butler, it seems as if the administration is ignoring the lawsuit that many states, including Ohio, are currently engaged in with the EPA, and instead they're solely focused on the implementation of the rule. Given all the legal issues surrounding EPA's 111D proposal, would you support the EPA setting aside the implementation planning until legal challenges are resolved?
Mr. Johnson, thanks for that question. I think Professor Tribe is far more eloquent than I am on these issues in the previous panel. But I think, to your point, I think that's the exact request that we would have and have made to U.S. EPA to have them consider. I look at it from a state resource application. We will likely be, if the Clean Power Plan evolves as a final plan, much like the draft plan, and it still has what we believe are its legal flaws, be challenging that law with many other states. That will not, unless things change, relieve us from the obligation to be developing at the same time in a parallel path, expending state resources to develop a plan of implementation on a very tight time schedule that, as you've heard, we don't think that we can meet. Those are scarce state resources, frankly, we cannot and should not have to expend. So directly to your question, I would have advised and asked U.S. EPA, because there is no compelling deadline relative to this issue about carbon, that we set this implementation issue aside and have our requisite debate about the legal issues and then go from there.
Well, let's expound on that a little bit. States like Ohio and others that we've talked to here today are implementing a number of new and older EPA regulations, ranging from the mercury and air toxics rule to particulate matter standards to new ozone rules. So can you expand a little bit? Doesn't this put strain on state resources? And what happens if on top of all of this, states also have to implement a final 111D rule that eventually could get thrown out in court? And the reason I say that is because we've seen that scenario before. The brick industry invested hundreds of millions of dollars into complying with a set of standards that the courts threw out, and then they got virtually no credit by the EPA for all of that investment that they did. And the EPA certainly was not standing there ready to give them their money back. Secretary Vandervaart, if they do get thrown in jail, they better not call me for bail money, because I'm not going to be at the table. How do you feel about that,
yeah,
Mr.
Johnson? Thanks for that question. I think we have seen we always are trying to comply with our delegated programs and certainly our air programs. We've made tremendous success in air quality in Ohio. We've seen an unprecedented number of regulatory requirements come down the road. So you mentioned the mercury rule. Not only does that add to the time commitment and planning and implementation for compliance, it's frankly having to shut down a quarter of our coal generation fleet in the state of Ohio. So we're concerned about that. Today, ironically, as we sit here, is the same day that we're required to submit our comments on the proposed new ozone standard. And we are just on the cusp of, frankly, getting to the point of being statewide full compliance of the 2008 ozone standard. I would love to, frankly, declare victory on that and say, but no, we're in a position now where we're having to decide whether or not we need to drop that standard further and whether or not the science is supportive of that. We're in addition in the midst of looking at both the particulate matter and SO2 rules and whether or not, frankly, we move down the path of having additional ozone transport regulations, and the list goes on. So that puts an incredible strain on us as state regulators and implementers, and is frankly just an additional cost that we're requiring through our legislature to pass on to customers.
Well, thank you. Mr. Secretary Vandervaart, do you have a comment on that as well?
Well, I'd just like to emphasize again, America is moving toward cleaner energy. It's moving that direction because of the free market and our revolution in natural gas exploration and production. We are all states doing what we think is right in cleaning up the environment, and I think it is not a time to rush to judgment when we have such a flawed proposal.
Thank you very much. Mr. Chairman, I yield back.
Gentlemen's time has expired, and I want to thank all four of you for joining us today to discuss this significant issue. I would like to also include the following documents in the record. A comment submitted to EPA on the proposed 111D rule by the Florida Public Service Commission and the Florida Office of Public Counsel. And we'll keep the record open for 10 days. I was going to come down and say hello to each one of you personally, but we have a vote on the floor, and it's almost 15 minutes gone now, so I'm going to rush out, but we look forward to working with you. Thank you very much, and that adjourns today's hearing.
Happy birthday.